Bill 2017 committee stage. Are we up to section 13? Oh no, hold on. I'm on the wrong page. Section 1. That section 1 stand part of the bill. Agreed? Agreed. Section 2. That section 2 stand part of the bill. Agreed. Section 3. That section 3 stand part of the bill. Agreed. Section 4. Section 4 stand part of the bill. Agreed. Section 5. That section 5 stand part of the bill. Agreed. Section 6. That section 6 stand part of the bill. Agreed? Agreed. Section 7. That section 7 stand part of the bill. Agreed? Section 8. That section 8 stand part of the bill. Agreed? Section 9. That section 9 stand part of the bill. Agreed? Section 10. That section 10 stand part of the bill. Agreed? Section 11. That section 11 stand part of the bill. Agreed? Section 12. That section 12 stand part of the bill. Agreed? Agreed. Section 13, that section 13 stand part of the bill. Agreed. Section 14, that section 14 stand part of the bill. Agreed. Section 15, that section 15 stand part of the bill. Agreed. Section 16, Amendment 1, a new section in the name of Senator Higgins. 1 to 4 inclusive and related and may be discussed together by agreement. Is that agreed? Yeah. Agreed. I'll ask Senator Higgins now, Senator Alice Mary, to move Amendment 1.
Okay, so to move amendments, am I to speak to amendments 1 to 4?
Yes, they're related, you may, yes. That's what you've agreed.
Thank you. I'd like to welcome you to the House, Minister, and to highlight the issues that I'm speaking to here in amendments 1 to 4 are issues concerned with the public service card. Not specifically with the public service card in itself, but with the public service card in the manner in which it has been rolled out and the data base to which it is attached, and indeed the procedures under which specified bodies are accessing that data. And I mean, the very immediate concern, and I recognise that many of these issues will be looked at in the pensions, in the Social Welfare and Pensions Bill, but there is a very immediate concern in that this card has been rolled out and is being rolled out in what I believe to be a very heavy-handed fashion, a fashion which we have been told is mandatory, if not compulsory, and increasingly we are hearing story after story emerging of those who are being denied access to essential services or supports which allow them to live a dignified existence if they are not willing to participate in the process and give their data over to get a public service card, and indeed have that data then fed into the single customer view data set, which is, of course, where data gathered for the public service card goes. We saw the case of the pensioner during the summer who was denied her pension and who then was later granted that pension despite very, very strong avowals that she was not would not be able to access and would have to forfeit that pension. We have seen cases of those, most recently cases emerging of those who have been denied access to SUSI grants, access to important student grants that allow them to attend college. We've heard of the multiple letters which people are getting, telling them that they need to come in, being informed that they will lose child benefit, that they may lose essential payments. And in all of these cases, I would emphasise what I'm actually doing in many of these amendments here. I don't believe that the department, or indeed the specified bodies who such as, for example, the Road Safety Authority in terms of the driver's licence and others who are demanding this compliance with having a public service card, I don't believe that they are acting within their boundaries and within the boundaries of the legal. I don't believe that they have, and we haven't yet been satisfied that there is a full legislative basis to allow that demand to be made, to allow the possession of this card to be mandatory for the receipt of these and access to these essential services and receipt of these services. We have not seen a satisfactory mandate, and indeed very serious concerns have been raised around, for example, the single customer view data set with information that was obtained under FOI, for example, highlighting that the ministerial agreement from 2009, which allows data to be shared between the Department of Social Protection and DPAR, was not signed by a minister. That's a very small concern in the bigger picture, but it's an example of a lack of robustness in how this information has been gathered, how it is stored and how it is shared. There's been very serious concerns, most importantly expressed by the Data Commissioner. The Data Commissioner has not simply asked for questions and answers, because she did ask questions. She did receive a number of questions and answers back from the department, and subsequent to that has gone on still to initiate I'm going to give the full title here, a Title 10, a Section 10 investigation. This is the first time that the Data Commissioner has launched a Section 10 investigation. And she is not and that is an investigation around the storage, collection and sharing of data within the Department of Social Protection, and of course pointing into that wider question of the single customer view data set. This is a very real concern, Minister, and of course this is not the first Data Commissioner to be concerned, because the outgoing Data Commissioner, who predates the current Data Commissioner, also expressed extreme concern as to how data was managed within the Department of Social Protection. Minister, this is not to point at you or even at any officials, but this is concerns from those who we appoint as the state to guard us, to ensure that we hold ourselves to the proper standards in terms of data. And what my amendments are doing is simply seeking to further clarify and underscore. I believe that, Minister, you have the discretion to accept other forms of identification besides the public service card. Minister, I also believe that specified bodies do not have the power to insist on a public service card. But what my amendments are seeking to do is to clarify and make it very, very clear, lest there be any doubt, that there is the capacity to, in the first one, accept such information or documentation as the Minister, an officer of the Minister or a payment service provider may reasonably require for the purposes of authenticating the identity of the person, and to spell out that reasonable requirement may not necessarily need to be the public service card. For example, Minister, if the Safe 2 standards are your primary concern, it is at your discretion, in terms of determining eligibility for a payment, to demand Safe 2 standards be met on a single occasion. And I do believe you would probably have a better sanction for demanding Safe 2 standard be met on an occasion in order to consider and grant eligibility for a payment. Where I think that the question marks arise is in the addition of that information to the single customer view data set, and in the subsequent sharing and accessing of that information by over 40 specified bodies. There are huge questions as to those who give their data for the purposes of accessing a payment can be said to be agreeing to that data being used for what is sometimes called excessive processing or additional processing by these specified bodies. There's a question mark there. Minister, in terms of the regulations which we are, as a European community, bringing into play from spring, the General Data Protection Regulation, GDPR 169, it sets out very, very, very clear parameters on the storage of information, the processing of information, and crucially on consent. And the requirement in the bar that it sets is for full, fairly obtained and informed consent. That cannot be, in terms of full and informed, the question, have people been fully informed as to all the uses that this data they are giving will be put to? In terms of fairly obtained, is this information, and has this been information gathered or compelled by threat? If so, it will fall short of the standards of the GDPR. And one can certainly find it hard to see how the potential loss of payment, loss of access to education, loss of right to drive would, for example, not be seen as a threat and an attitude of compulsion. Minister, there may be many who voluntarily and willingly and even enthusiastically have sought to get a public service card. However, those who have been compelled, those who we hear the stories of them being compelled and being told this was the only form of identification which will be accepted, they are having their rights effectively violated. And subsequent to GDPR coming in mid-spring next year, it will apply not only to the gathering but to the usage of that data. So, Minister, those who are compelled to give their data, if that data is used subsequent to June or May, whenever the GDPR is initiated here in Ireland, they will have a case. And the GDP comes with very substantial fines. The fines go up to 4% of a body's turnover. You know, it's a very serious issue, Minister, and this is why I'm in these amendments effectively trying to seek to encourage you to exercise your control and your discretion to ensure that we strive to ensure that we are as compliant as possible going into that period of time, and that we don't leave hostages to fortune in the future. Effectively, we have seen the concerns raised by the Data Commissioner and a doubling down of the rollout. This is an urge and a plea, effectively, for the Department and indeed for the Government in terms of the DPAR as well, to stop digging on the public service card, because you're creating trouble for us down the line as a nation. In terms of the questions of fraud, which was the heavily used justification, that we must be satisfied the risk of all those who are presenting with the identifications of others. I think we saw in the Public Accounts Committee recently, where the figures on fraud proved to be highly, highly exaggerated and that there were concerns. We had fraud levels, what had been reported as fraud levels of 2%, but it emerged that over two-thirds of that, 1.4% of that was departmental error, and fraud was left at 0.6%. What tiny fraction of that can we assume to be based on the presentation of false identification? And is the only way that that false identification could be recognised and rectified is through Safe2 and the rolling out of a hugely widely expensive public service card? Minister, I believe that the imposter argument at the front line of public services is a straw man. I think the incidence is very small. And if a straw man is presented to us as policymakers, we do have to challenge it, and we do need to challenge it, because there is a far more robust and more serious threat on the other side. I know I'm speaking at length, but I will conclude shortly, but I wanted to speak to these amendments effectively as a whole, and I will just now add one or two specific sentences in regards to each amendment and why I hope you might take them on. And again, Minister, I recognise that in the current world, data is mined, data is used as currency, data has been effectively, many of the threats to citizens have been in terms of how their data is used by corporations. Europe, and as Europeans, we've taken a strong stand, and I'm very proud of our directive that we've collectively produced in 169. But we do, even though it may mean changing historical practices, and rather than say layering, what I think we've done here with the public service card is layering a new entity over historical practices rather than fundamentally rethinking how we do consent, how we gather data. And I do think we need to hold ourselves to the highest standards so that we can legitimately represent our citizens and protect their data in the wider data sphere, and so that we can ensure that people feel empowered to feel that just because you are living in the modern world and you are accessing things, and I don't think anybody who opposes this, I don't think they're Luddites. If anything, some of the people who have opposed this and spoken about their concerns are people who are most engaged with technology, and they want to ensure that we are acting in a way where citizens are empowered around how their data is used and how it is collected. And I think that's something we should aim for collectively. And of course, there are those who are very vulnerable and who are very frightened and who have taken this card and expressed that they're not sure what they're signing up to, and they're not. And those concerns have come through to us as well. And again, we saw that case in terms of the pensioners. We saw the case of a person who had been adopted and had to give excessive and inappropriate information in that context, and so forth. Very simply, the First Amendment specifies, again, I believe it is already the case that the Minister has discretion to accept another form of authentication for identity, but it seeks to spell that out. The second, and in the later sections, it does this under a number of different criteria. And then simply, this is where this is a sentence, because there has been some ambiguity. We know that under the European GDPR rules, you cannot make it be compulsory for someone to share their data. However, we have been told that it's mandatory. So in that context, I'm seeking to spell out possession or production of a public service card shall not be a mandatory repayment for a payment of a benefit. Perhaps, Ministers, there's other ways in which you can assure me as to that, but that is simply seeking to spell out. I don't believe it should be necessary, but there we have it. Number 2 simply sets straight out again the question of that this really is a report which will set out and make it very, very clear that the compatibility of all measures that will be put with the General Data Protection Regulation. I know we will be ensured, and I'm sure all of government, and I know there are bodies within DPAR that are working to implement GDPR, etc. But given the kinds of concerns that I've highlighted today, this is why I was targeting and looking for a specific report in respect of the public service card and SAFE2 and the data set gathered by the Department of Social Protection. And my condition here would be that the information gathered for the public service card purposes shouldn't be shared. It should be effectively single usage until we have used for the Department of Social Protection for the initial function, rather than shared with the single customer view data set until we have those assurances. And again, when we have those assurances and proper procedures in place, so be it. I'm urging an approach which is caution until we get it right, rather than plough ahead and then fix afterwards. In terms of the third amendment, there's been some ambiguity around the question of biometrics. A photograph which can be biometrically read is biometric. So this is really to clarify, because there's been we've had different statements at different times from different parts, for example, of the department, around whether the photographs are biometrics, whether these cards are biometrics, have we had a proper debate on the use of biometrics. And the simple fact is, if there's a photograph and it's allowed to be biometrically read, it is effectively biometrics. But what I've tried to really clarify here is, if we're not ready to have the debate on biometrics and properly discuss that and look at our standards put in place, then for now, any photograph gathered for a public service card should not be shared or subjected to biometric reading and cross-checked against the database of biometric information. I realise there may be imperfections in how this amendment is drafted, Minister, and I'm happy to work with those for report stage, if necessary. Number 4, my final amendment in this section. Minister, I'm asking, this is in this amendment, and this is the one that I feel I need to press, because it is urgent, unless you can indicate that there's any other way that clear direction will be given. A person shall produce his or her public service card at the request of a specified body for the purposes of direction. Now, again, I may look at amending this slightly or perfecting it, but the key question is, no specified body shall make possession of a public service card a mandatory requirement for the purposes of a transaction. And that is a key concern, because we do have that situation where, at the moment, I believe many of the usages by the demands for a public service card as mandatory by specified bodies is acting on a very shaky legislative ground and basis without proper consent having been given. I'm simply urging that the state would exercise appropriate caution until that's addressed. Thank you very much, Minister.
Thank you, Senator. Now, Minister.
Thanks, Senator. So, I'm not proposing to accept any of the amendments, and the amendments relate to the public service card, but also relate to the General Data Protection Regulation. So first, I'd like to make some points just about the PSC card first, and then if I get to the end of the spiel, you might remind me about the fourth amendment, just in case it's not included, because I want to make a specific note about that. So the main legal powers providing for in relation to the PSC and the safe registration process are set out in the Social Welfare Consolidation Act of 2005 as amended, and they are as follows. Section 262 and 263b provide for the verification of an identity to facilitate the issuing and use of a public services number, which is our PPS number or our PPSN. Sections 263, 263a and 263b provide for the verification of identity to facilitate the issuing, use and or cancellation of a PSC. Section 241 provides that a person must satisfy the Minister as to his or her identity when making a new claim, and it sets out how they might go about that. And Section 247C provides that an existing claimant must satisfy the Minister as to his or her identity, sets out how that would be done, and provides for the disqualification where an existing claimant fails to do so. So the safe registration is the process that's used by my department to establish and verify a person's identity so that it can be sure that, number one, that the person using its service is the person they claim to be, Number 2, that nobody else is using that person's identity for the purpose of claiming a service or a payment. Number 3, that the person is not claiming another payment or using another service under a different identity, and in addition, to minimise the requirements for people to provide the same identity information over and over again when all they're doing is accessing public services. The acronym SAFE stands for Standard Authentication Framework Environment, and it's a standard for establishing and verifying an individual's identities for the purpose of accessing public services, and it was agreed by the then government in 2005. The SAFE standard has 4 levels: SAFE 0, which is no assurance of identity; SAFE 1, which is the balance of probabilities and the minimum authentication level, which is allocated for the current PPS number; SAFE 2 is a substantial assurance, the minimum authentication level for issuing a public services card; and SAFE 3 is beyond reasonable doubt, and that would be if we ever got to a situation where you'd be using, for argument's sake, fingerprinting, which would be really biometric data. My department is implementing SAFE 2 registration on a phased basis with its customers and the customers of other services, public services that require identity verification to a substantial level of assurance. Until recent times, many public services were provided to people who had their identity verified only to SAFE Level 1 standard. For example, identity documents such as passports or driving licence were issued following SAFE 1 level equivalent registration processes. And since the introduction of the SAFE 2 level registration in 2011, more services are now moving to the identity verification of this level to ensure that we have a substantial assurance of somebody's identity. And while it's a matter for each public service provider to determine the appropriate level of identity verification required for each of its services, it is government policy, both this government, the last government and the Fianna Fáil government beforehand, that SAFE 2 registration is required for access for all services that require a substantial proof of a person's identity. My department makes it clear to customers in receipt of welfare payments or entitlements that they do need to register for the SAFE 2 verification process in accordance with the relevant legislative provisions, or access or continue to access those payments and or entitlements. And once a customer completes the SAFE 2 registration process, they may be issued with the public services card, but they may not be. They don't have to have a public services card. The PSE is replacing older documents used to show entitlements to a benefit, including social welfare services card and, in some cases, the former paper travel pass card for our free bus and rail travel. So accordingly, it will be in the future necessary to provide a PSE card as proof of identity for certain types of transactions, including collecting welfare payments at a cash or in cash at post offices, or for those old age pensioners and other people who get the free travel pass, it will be on their card. And the recently published comprehensive guide to safe registration and the public services card is available on my website from the department. This document was compiled as part of my department's ongoing engagement with the Data Protection Commissioner, and it contains 54 detailed questions and answers which address the wide range of questions about the safe registration and the PSE, including a very explanation that while the PSE does store a person's photograph, it does not store the arithmetic template of that photograph. And it also explains that the arithmetic template is not stored on the public services identity data set that we hold off-site in storage, and we don't share that with other people. So therefore, we don't hold biometric data. And I know we can split hairs, right, but we don't hold it. So it's something that's taken at a registration process, but it's certainly not held by the department. Appendix 1 of the guide lists the legislative provisions associated with the public services card, and Appendix 2 contains the full list of specific bodies that may use public services identity data set under sections 260 to 265 of the Social Welfare Consolidation Act of 2005. And primary legislation is used to add new bodies to this schedule should we ever feel the need to. So now let's talk about the General Data Protection Regulation. The GDPR, which will come into force on the 25th of May 2018 next year, will replace the existing data protection framework under the EU Data Protection Directive, and it will impose a general necessity to have specific legislative provisions underpinning the methods organisations use, such as my own, to process data. The GDPR has very significant implications for the way the civil and public service does its business, and by using a regulation rather than a directive, the EU legislature is aiming to have more uniform applications of EU data protection laws across Member States than was the case under the previous EU data protection regulation. The GDPR is a complex piece of legislation. For example, it contains 173 recitals, where the preliminary paragraph setting out the objectives and the intentions of the EU legislation and which guide interpretation but are not directly binding. In addition, there are 99 articles which are operative provisions which are binding on EU Member States. And due to this high level of complexity, even though the EU legislature has opted for a regulation, there remains a real need for national implementation legislation in order to give full effect to this regulation at a national level. I think you're aware that my department collects and holds large volumes of personal data on customers, and we are very aware of the need to have adequate data protection policies, procedures and structures in line with the GDPR. And preparations for the GDPR are being overseen by my department's Data Management Programme Board, which comprises many of the department's most senior personnel, and the department has a dedicated GDPR implementation team in place and has commissioned external expertise to assist with it achieving our GDPR compliance. In addition, my colleague, the Minister for Justice and Equality, has published the general scheme of the Data Protection Bill, and my colleague, the Minister for Finance and Public Expenditure and Reform, is working on the Data Sharing and Governance Bill to simplify data sharing between public bodies. Officials from my department are also examining both legislative measures in light of the GDPR and the relevant rulings by the Court of Justice of the European Union. So, to conclude, I believe there are already strong frameworks and safeguards in place within the legislation governing the use of the PSC, and that the necessary steps that are being taken in relation to ensuring compliance with the new GDPR. I should also mention that the Social Welfare, Pensions and Civil Registration Bill 2017, which is currently progressing through the Dáil, includes a number of specific provisions relating to the PSE, and actually I genuinely think that that bill would offer a more appropriate vehicle for discussing the issues raised by the Senator, given that at that point, when we come back in the new year, our GDPR scheduling team will have advanced their preparations. We'll be closer to the 18th of May deadline. But also, just to let you know, the last amendment that you've spoken about is that there is no legal entitlement to produce a public services card. The public services card is a byproduct of the Safe 2 authentication process. And so therefore your number, having completed the registration process, is what's vital for accessing other services such as SUSI or whatever. It isn't specifically the card that's, you know, the magic piece of information.
Minister, I hate...
Order.
I'll come back. Yeah.
Sorry, Minister, you're finished.
No, so sorry, just to wrap up though, although I would prefer and ask you that you would withdraw the amendments, obviously, and we could have a further discussion at the Social Welfare and Pensions Bill. It is my intention, obviously, not to accept these amendments, Senator. Sorry.
Is the amendment being pressed?
I'm responding.
Well, I don't necessarily need to.
I know. I'll be very brief on other
You've both spoken very fully. The Minister has said she's not accepting the amendments. So I'm entitled
with respect,
yeah.
look, I'll exercise my right to respond.
I know. I want you to speak to whether you're going to press it or not, the amendment. You've both been very full on this.
Sure.
We've wasted over half an hour. Sorry.
I don't regard it as wasted time. I think it's an important discussion.
Senator Higgins.
Just a couple of key concerns. Minister, I appreciate the fulsome response that you've given. I look forward to engaging with you and debating this issue and discussing it with you. Hopefully just when the Social Welfare and Pensions Bill comes to the House, but I hope that we will have the opportunity to engage on it in advance of that to ensure that, because there are a number of provisions which are, I think, perhaps even more concerning, unfortunately, in the public service, mixing it up with yesterday's bill, with the Social Welfare and Pensions Bill as it stands, and particularly, I think, with one of the sections of that bill. So I may engage with you further on that, Minister, and I'm sure you're aware that in the Committee for Social Protection, which my colleague Senator Seanad is also on, we will also be looking at this issue in the spring. I think I could have waited for that bill, but the concern is that we have seen an acceleration of the push-out, the promotion, the demands for the public service card. What I would have hoped is that when the Data Commissioner expressed such serious concern, given that we are still waiting for, as you talked about, the proper full response of how do we implement GDPR, that we may have entered a period of slowdown or caution where we seek not to drive something forward when we don't know if we are on the right path or proceeding in the right manner. The amendments I'm proposing here today, I'm not going to push all of them, but I will push maybe one or two, but they are an attempt to apply the brakes. These are not a radical restructuring of these bills. These are literally an attempt to apply the brakes while we wait and ensure that we get our house in order and key. One key concern, Minister, you mentioned, and it has been mentioned widely, the need of this for identity verification in order to access services. We should be very clear that, in fact, the public service card under legislation at the moment cannot be used as a method to identify verification. It is used specifically for the purposes of a transaction. And so there is a key question as to whether or not, and there have been questions and there are further questions about whether or not some of the usages to which it has been put in terms of identity verification in fact fit the constraints of the definition of a transaction. And Minister, I would just add, it is not sufficient to have the PPS number, because I know, for example, I myself have sought to access a service and been denied that because even though I have a PPS number and my data says there, because I didn't have a public service card physically. And I know that that's an experience many people will have had, and they certainly have it in terms of even, for example, seeking a driver's licence at the moment. You cannot get a driver's licence with another form of identification and your PPS number. You are required to have the public service card at the moment. You shouldn't be, perhaps, but that is the case. That is what is happening.
You're actually, and sorry to interrupt.
Just if I'm incorrect.
No, you're actually not, right? But I feel like we're splitting hairs now, because both of them.
No, I just wanted to clarify. If that's not the case, it would be great to know that.
You're not required to have the card. It actually is illegal right now today for anybody to ask you for the card. But what you are required is to have gone through the Safe 2 authentication process. And the only way you can prove that you've gone through the Safe 2 authentication process is to get the number at the end of it, the registration number from the Safe 2.
So not your PPS number, but the new number of entering this new database.
Yeah.
Okay, again.
So the card is actually, and I know we're always focusing on the card, but the card is actually relevant.
No, I understand your response, Minister. Again, it leaves my concern standing. So anyway, I thank you, Minister. I'm going to engage further with you. We look forward to looking into it again. I wish that we had, as a state, adopted a more cautious approach. In terms of the amendments, you'll be delighted to hear I'm now moving to whether I press them. And in terms of Amendment 1, I would like to press Amendment 1.
Okay. The new section be there inserted. Those in favour say tá.
Tá.
Those against say níl. Níl. I think the question is defeated.
And in terms of Amendment 2.
Are you moving to?
Yes, in amendment number 2. I will press that also, just for now.
Okay. Those in favour say tá.
Tá.
Those against say níl.
Yeah.
The question is defeated.
Okay, I'm going to withdraw amendment number 3 because I believe it does need to be.
Is that agreed?
Yes, I withdraw, but I reserve the right to bring it back.
Of course, that report said, yeah.
And I would also reserve the right to produce an amended amendment on some of these other issues.
That would be your right.
The further.
So
and then
3 is withdrawn by leaving the House. Agreed?
Yes. And
Amendment 4, rather.
Amendment number 4. I do need to press this, I'm afraid.
Okay. Those in favour say tá. Those against say níl.
And I will say vote all on this amendment.
Vote all.
Symbolically. Yeah,
vote
that's
all.
my only,
vote
to be my
all
only vote
4.
all of the day.
Vote all. Okay, thank you.
Social Welfare Bill 2017 Committee Stage, Amendment 4, name of Senator Alice Mary Higgins. The question is that a new section be there inserted. And on the question, division has been challenged. Tellers toss, Senators Alice Mary Higgins and Senator Francis Black. Tellers need Senator Gabrielle McFadden and Senator John O'Mahony. Time allocated for voting is 1 minute starting now. Time allocated for voting. The result of the vote is TAW 14, Neil 25. The amendment is lost. Are you going to hear again? Thanks.
Stand part of the bill. Agreed? Agreed. Section 17. The Section 17 stand part of the bill. Agreed? Agreed. Oh, no. Where's my minister? Oh, yeah. Send in the minister, please. Section 17 stand part of the bill. Agreed. Section 18. The Section 18 stand part of the bill. Agreed. Section 19. The Section 19 stand part of the bill. Agreed. New sections. New sections. Amendment 5. The names of Senators Devine, McLaughlin, O'Donnell, O'Warfield, Conway, Walsh, Gavin and Norris. Senator Devine, Section Amendment 5.
Good morning, Glasgow here. We'll put this in for a report on. Sorry, I'd like to move the amendment to the bill. You want to say who's? On the go, Grant. Okay. A report on fuel poverty in Ireland. Research has shown that people over age 65 are 7 times more likely to be hospitalised, and I know that myself, as a result of freezing temperatures compared with those aged 18 to 44. Hospitalisations in poorer communities due to cold weather are 2.5 times more common than in the wealthiest neighbourhoods. We can't underestimate the effect that fuel poverty has on health and well-being of our population. The justification for this amendment is to ensure adequate scrutiny is given to fuel allowance policy, given the extreme impact that fuel poverty has on the health and well-being of many people in our society. A report as described above will allow both houses of the Oireachtas to have the necessary information to adjust allowances in light of its reporting. Minister, during this bill's progression in the Dáil, you did agree to this amendment in principle. You agreed to support a revised amendment at report stage, but you have not done so. This amendment affords you the opportunity to keep your word. We are hopeful that you will therefore support this updated amendment in the Seanad, along with members of this House.
Thank you, Senator. 1 second, Minister. Sorry. I think Senator Arda wants to say a word.
Thanks very much, Minister, for coming to the House. I want to just mention a very short matter in relation to the fuel allowance that I mentioned before at the committee stage, just in relation to the income threshold, and perhaps your department might consider increasing the income threshold slightly, as once you're in receipt of fuel allowance, not only do you get the fuel allowance, but you also get ancillary benefits. So it's just something I'd like to put on the record of the House.
Senator Alice Mary Higgins, do you want to say a word on this?
I really say that I think that it's a very important issue that's been highlighted, and we know that we've seen in terms of the cold snap weather that we've had now and the concerns that have been there, that there are concerns, and that we have in terms of fuel, the costs are very variable and move around, and that they change. And I think it's an issue that's been highlighted by Senator Devine previously in the House. I support her push, and I hope that the Minister is able to give satisfaction to the Senator in respect of this issue.
Thank you. Minister.
Thank you. Thanks, Senator Devine. So I'm not proposing to take this amendment, and the reason I'm not is because fuel allowance is just one element of the government's strategy to tackle energy poverty, which is complex and multidimensional, and it can be looked at a situation in which people are not able to adequately heat their homes or meet other necessary household energy services at an affordable cost. And the reason I said at the committee stage in the Dáil that the motion couldn't, or the amendment couldn't be kept, was because it isn't within my remit. It would fall under the Department of Communications remit to look at the entire, I suppose, effects of energy policy or lack thereof over and above what I can do, which is only income support. And I think you'd have to be fair to say that with the support of Fianna Fáil this year, we did extend the fuel allowance calendar by 1 week, and I would hope and I'd expect and anticipate with continued support to be able to increase that as the years go by. In 2016, the Government launched a comprehensive strategy to combat energy poverty under the Department of Communications, Energy and Natural Resources. And this followed an extensive public consultation. The strategy builds on the progress and experience developed over the 4 years since the first ever government strategy on affordable energy, and it expands the range of existing energy efficiency schemes and commits government to developing and piloting new measures to find more effective ways to focus on energy efficient efforts for those most at risk from energy policy, because you do describe it very adequately well. But it puts in place the structures and the accountability to ensure that the challenge is effectively addressed at every level of government that has an impact and responsibility for addressing that issue. Whereas our own department, the only responsibility that we have is to ensure that the payments that we make, which are income supports, are provided to the people that they so generously need it and depend upon it. The fuel allowance scheme assists pensioners and other welfare-dependent households to meet the cost of their needs during the winter season, and it's a contribution towards a person's normal heating expenses, and isn't and wasn't ever anticipated to cover the full costs. The payment is made to over 376,000 of the most disadvantaged households in the country, including pensioners who are, as I agree with you, the most at risk from energy poverty. In recent years, there have been increases in both the amount and the duration of the fuel allowance, and as I said, in 2016 the fuel allowance was increased from €20 to €22.50 a week, and in 2018's budget we increased the duration from 26 weeks to 27 weeks with the support of Fianna Fáil. We also made changes in the last year at a genuine request from the advocacy agencies that look after people in this category to change the weekly payment to be on offer for people in 2 lump sums, and that has been taken up by tens of thousands of families and has been found very, very welcome. The Department also pays the household benefits package at an estimated $232 million, and that's on top of the $229 million of the fuel allowance support that we give every week or every year. Under the Supplementary Welfare Allowance Scheme, a weekly or monthly supplement can be paid to assist the people who are unable to meet their weekly payments because of certain circumstances. And this, in a lot of cases, does include fuel supplements. Excuse me. The average household energy costs from between €1,400 and €2,200 a year, and there's a significant variance between urban and rural household divides. So the urban-rural disparity is largely based on the nature of the housing stock, because a lot of them in rural areas are much, much older and don't have, the same energy ratings. And one of the primary reasons to focus on improving energy ratings through our local authorities is because of that exact existence. A couple disparity is one of the main reasons that we give a living alone allowance to people, which amounts to €468 a year. So I'm not proposing to accept this amendment because I've already mentioned we do have an across-government progressive and comprehensive strategy on energy poverty. It's readily available and it's currently being rolled out through the different departments. Excuse me, and my plan would be to improve the duration of the calendar in coming budgets. Excuse me.
Drink of water. Are you going to move this section?
I don't think it's a rocket science to know research and reports actually tend to improve outcomes, and if we're doing things in a proper manner, I don't think it's a big ask. I'm disappointed that it's not going to be accepted, and I will push the amendment. Thank you.
Amendment has been pressed.
Yeah. Pressed.
Those in favour say taw.
Taw.
Those against say nil. Nil. I think the question is defeated.
Vote taw.
Vote taw. Thank you.
Your seats. Social Welfare Bill 2017 Committee Stage Amendment 5. In the name of Senator Maura Devine. The question is that a new section be there. The new section be there inserted. And on the question, the division have been challenged. Tellers Taw, Senator Maura Devine and Senator Neil O'Donnell. Tellers Neil, Senator Gabrielle McFadden and Senator John O'Mahony. Time allocated for voting. 1 minute starting now. Voting. That was close. Very close. Result of the vote is Taw 15, Neil 17. The amendment is lost. Amendment number 6. In the name of Senator Devine and others, do you wish to move Amendment 6?
I wish to move this, Cathaoirleach.
Is the amendment being pressed?
The amendment's been pressed.
The question is that amendment be made. No, that a new section be there. Inserted. Those in favour say Taw.
Taw.
Those against say Neil. Neil. I think the question is lost.
No, vote all.
Vote on. Seats. Social Welfare Bill 2017 Committee Stage Amendment 6 in the name of Senator Maura Devine. The question is that the new section be there inserted. On the question of the division has been challenged. Tellers Toss, Senator Maura Devine and Senator Neil O'Donnell. Tellers Neil, Senator Gabrielle McFadden and Senator John O'Mahony. Time allocated for vote is 1 minute. Result of the vote is Taw 12, Neil 15. The amendment is lost. Amendment 7 in the name of Senator Arda Wilson. It's a new section. Is the amendment being moved?
Yes. Yes.
Is it being pressed? Do you wish to speak on it?
I'd like to speak on it.
So wait till the Minister comes in and talk, please. We have a lot of work to do, so those who want to chat can leave the chamber. And Senator Arda, you want to speak on this motion.
I'd like to speak on motion number 7 in relation that the Minister for Employment Affairs and Social Protection shall review the abolition of the bereavement grant, setting out options on restoring the payment, and shall bring forward a report on same within 6 months of the bill being enacted. We know that the bereavement grant was a once-off payment to help with funeral expenses and funeral costs. Eligibility for this grant was not related to your ability to pay for the funeral. Eligibility was based on PRSI contributions. And our motion is looking to have a review done of the bereavement grant, obviously with the hope of restoring such a grant. And I'd be moving the motion.
Okay, Minister.
Moving the amendment.
Oh, sorry, I let the others in. Since Divine.
Sorry.
Will be supporting this amendment to the bill. It's a pity they didn't think that report for under 26-year-old job seekers allowance and field poverty was worth voting in favour. Gormagal.
Okay. Senator Higgins.
We didn't, because it was facilitated a speedy vote. The previous amendment on job seekers allowance wasn't debated, and I just want to note that I do think it is very important, and it would be useful if it becomes possible later in the debate if the Minister, I know, didn't get the chance in this case, but to comment back, because I do think that there are very serious concerns in terms of the under-26s and their treatment, and of course given the very, very high record of emigration that we have had in recent years of losing young people. In terms of the bereavement grant amendment, I would like to support the proposal from Senator Arda, and I think it would be important to look to it, but also to look to it in the context of the wider set of supports that are given to those living alone subsequent to bereavement, because there is also a concern in terms of the living alone allowance, which I know is still not adequate to purpose, and we do have particularly women often left living alone and on far severely reduced pensions after the death of a spouse. So perhaps if that could be touched on in addressing the question.
So I let the Minister in now.
Thanks, Ciaran Corley. So I'm not proposing to accept this amendment. The bereavement grant was an insurance-based payment, so it was entirely based on the amount of credits that somebody had. And it was valued at €850, and it was usually paid to the person responsible for paying the funeral bill. The scheme was abolished in 2014, and in 2013 the value of the scheme probably amounted to just over €20 million. Now, given that obviously it was abolished at a time and to people who were in the main not the most vulnerable people in society, the social welfare assistance payment and the supplementary welfare allowance scheme that was always around, even when the €850 was being given to people who didn't necessarily or couldn't necessarily afford to bury their loved ones. These exceptional payments are made to the most vulnerable people in society. The government provided just over €31.5 million in total expenditure for those payments last year. The average payment amounted to just over €4.4 million in total, with an average payment of €2,700 per family excuse me, for bereavement and burial expenses for those people who genuinely could not and did not or were not able to afford the expenses towards their burying of their loved one. In the intervening years under supplementary welfare allowance, it's broadly the same in the last number of years. So 2014 we had 4.6 million, 15 and 16 we had just over 5 million, and 2017 again it's just 5.2 million. The average payment, as I said, is just under €3,000, and I think, in fairness, I know it was something that obviously Fianna Fáil wanted to look at in the budget, but during our budget negotiations, the value of the money that we were talking about that would have to be given to every single social insurance contributor was obviously deemed to be more, I suppose, effectively spent to people who are genuinely vulnerable, such as the increase in the qualified child allowance, the increase in the fuel allowance by the extra week, the increase of the €5 and pro rata pension payments to all of our old age pensioners, our blind pensioners, the people who have disabilities, the inability to work, people who are on partial capacity payments, all of those people who are genuinely vulnerable, and also to exist and maintain the current practice that's within the Department of Social Welfare to maintain the practice of looking after people with regard to burial and funeral costs who are vulnerable and can't afford to pay for themselves.
Has the amendment been pressed? Yes. The question is that the new section be there, and certain those in favour say Tá. Those against say Neil. The question is lost. Amendment number 8 is also a new section, and it's in the name of Senator Arda. Again, do you wish to move? I declared. Well, I called it. I can't reverse. So I'm sorry.
Because I said that we were pressing it.
Well, you did indicate that. So. Yeah. Okay. Voice got. Okay. We can't reopen it apparently. So. I can't make one route for one and another route for another.
I did say we were pressing it.
And she did press it.
And I pressed it, and in my speech I pressed it.
Yeah, but when you had a chance of, I said the question is lost, you should have said vote all, or call for a vote, and that wasn't done.
Well, I did suggest that I was pressing it, which is the same thing.
Well, look, I have to adjudicate, and I've given the result, and I'm not going to change. Otherwise, it's happened before, and I think there's an issue about. I just can't reopen. I'm sorry, Seanad.
I was very firm in terms of saying I was.
No, but you'll have to call for a vote. No? You did press it, and I put the question, and the House gave a result of I said those in favour said Tá, you said Tá, the government side said Neil, and I said the question is defeated or lost, and
I think you went very quickly. I don't think it was fair in terms of the time frame.
I can't do that because if we procrastinate on every issue.
Literally, I'd say it was less than 5 seconds you gave before you moved on, even less than that. So I think administratively it's quite unfair that you've pressed it and you've moved on without allowing me, to push a vote. Well, I think if you were to look at the time frame, I would say it was even less than 10 seconds.
When we put the question, and if I announce the result that the amendment was lost, I have to move on to the next item. Otherwise, we say we'll allow a minute in between.
With due respect, I think that literally you would have given this. I think if we look at the records, it will show that you've moved on in less than 30 seconds.
There's no time.
What happened when the previous amendment was that we had moved and pressed it without me even being here, which I think is highly unorthodox. But we do move on at a pace.
Yeah. Okay. Look, I made a ruling. I can't. I will go on to number 8. You have a chance at number 8 since I'm sure the issue will be revisited again. I can't, because if I reopen that one, I have a system of trying to move things along, and I regret you were caught offside. I didn't intend to do that, that's not my style, but we're on to number 8 now, and I ask you to move it.
Report stage or proposed at report stage.
Well, yes.
A similar, if not identical, amendment. So I think it has to be arising from the discussion of that issue.
Well, the report stage hasn't come yet. We're not doing a report stage until tomorrow. So we're on a number 8. I just can't go back, unfortunately. Sorry. Number 8, Senator Haddad. Do you wish to move it?
Yes, please. I'd like to speak on it also.
Okay.
First of all, I'd like to welcome the decision today to grant those in receipt of carers allowance a GP card, and I'd also like to welcome the increase in funding for respite grants. However, there is an issue in relation to carers and how carers are being treated and how payments to carers are being treated. And this amendment calls on the Minister for Employment Affairs and Social Protection to review all care-related payments under the remit of her department, and in particular the Carers Support Grant, with the view to determining its adequacy and suitability for current needs, and shall bring forward a report on the same within 6 months of the bill being enacted. We know, and we saw in recent primetime discussions, how there are over 200,000 people caring for their loved ones throughout Ireland, and this is actually there's a 35% increase in those over 85 caring for their loved ones, and it's a massive amount of free care time the state is getting. So I think we need to show a little bit more respect to our carers and ensure that payments, in particular, are protected and are reviewed, so that we can acknowledge the hard work that they do across the country. And I will be pressing it. And
just to clarify that last one, that there was an issue with number 7, you are entitled to reinsert that for report stage for tomorrow, so you'll have a chance to vote at the end of it. I can make a ruling and go back in it. So, Senator Higgins.
Just to speak strongly in favour of this amendment in terms of the review of the care-related payments. I think that care is the lifeblood of society. It's something without which our economy wouldn't function and without which society wouldn't function. But all too often it does become somewhat invisible, and it's not given the full acknowledgement that it should be given. Particularly, for example, I've long pressed not only for the homemaker scheme to be addressed, which we've discussed previously, Minister, and we'll discuss, I'm sure, again today, but the question of a care credit and looking to how we can move towards a modern social protection system that recognises the contribution of care. Peter Moss, who has spoken on this issue before, has said, I think very eloquently, that care always costs. The question is who it costs. Is it costing the time and energy and life force and energy and years of existence of somebody who is contributing to care? Does it cost the state? Does it cost money? Does it cost time? Care is never an invisible thing. It is something that always has a requirement that is there. And the question is how we can better ensure that the cost of care is managed, and we have had some progress with that, for example, in areas such as childcare. I very much hope, that we will see progress in areas such as home care and respite care, which give some relief and share that that challenge of care and that task of care, which currently falls so heavily on families. This is all part of the picture of recognising the importance of care, seeing how we can better support and contribute to it, and then also, yes, in terms of payments and in terms of the financial recognition of the needs and of the contribution of carers. We could improve and look to our carers support grant area. But another concern I have, Minister, it's yet another gap in our pension system, unfortunately, is that many of those who are carers do fall out of the system because if they have not been in our social protection system, are not been contributing and making PRSI contributions for a period of time previous to becoming carers, they will not necessarily automatically have contributions made on their behalf. So you have a gap. For example, those who go abroad and come home to become carers can fall through the system in different ways. So there's a number of ways in which people who are giving their time and their life to care can sometimes fall through our system and can both find themselves suffering great hardship during the time when they are caring, but can also find themselves penalised when they come to their own point of retirement. So, Minister, I think there's a few issues to be looked at. I think this is a really good opportunity. I hope you will be able to accept or in some way accommodate, indicating that we are going to look more deeply at the question of care as asked for by Senator Ardagh. Thank you.
Minister.
Thanks, Councillor. I want to say at the very outset that I think the Government, and indeed probably everybody in the country, recognises and acknowledges the crucial role that family carers play in our society, and we're fully committed to supporting carers in that role, and I think that commitment is recognised in the National Carers Strategy. Yesterday, as the House might be aware, that the Government agreed a new health service measure that will have a positive impact on the lives of people with disabilities and in particular their carers. Additional funding has been provided to enable all carers in receipt of a carers allowance or a half carers allowance to qualify for a GP visit card, as well as providing additional €10 million in funding to provide respite care for people with disabilities, and that's going to give us an extra 1,900 bed nights over and above what was agreed in the budget for 2018 already. And the GP card will be implemented once the primary legislation is passed in the beginning of the new year. The crucial role that carers play is explicitly recognised within our social welfare system. The income disregard and the means test for carers is probably the most generous within the social welfare system, and at the full rate of payment, the amount of weekly earnings disregard is €332.50 for a single person and €665 for people who are married in a civil partnership or cohabitating. The maximum personal weekly rate for carers benefit is €210, while the maximum weekly personal rate of carers allowance now stands at €209 for those persons aged 66 and under, and €247 for those people who are aged over 66. In the budget, alongside the support of my Fianna Fáil colleagues, we provided for an increase of €5 per week from the week commencing the 26th of March in the maximum personal rate of carers benefit and carers allowance. And we also maintained the non-means tested respite carers support grant of €1,700 per annum. Half carers allowance is paid in addition to certain primary social welfare payments where the carer meets the criteria for both of those schemes. In addition, where a person is being claimed for as a qualified adult on their spouse, their civil partner or their cohabitant social welfare payment, and is providing full-time care to another person, the half-rates carers allowance is paid in addition to the qualified adult allowance. So carers who provide care to more than one person may, for an additional 50% of the maximum carers rate each week. There are currently around 2,700 carers receiving carers benefit and almost 75,000 carers receiving carers allowance. Approximately half of the latter are receiving the reduced rate carers allowance along with another full social welfare payment. This year, in recognition of the value that we place on the care that's provided, we are going to, as a nation, spend €728 million on carers allowance and carers benefit, and another €180 million on the carers respite grant. And that's before we start to add the services that are provided for by the Department of Health, the Department of Justice or the Department of Education. The adequacy of payments to carers, like every single payment that we make to the Department of Social Protection, is kept under constant review So it isn't a case that we need a special report or a special review to reflect the adequacy of the payments, because it's done every single year as part of the budgetary process, and it will be obviously informed by any developments that are refreshed in the National Carers Strategy, which my colleague, the Minister for Health, has overall responsibility for, but also just to say that any increases are again entirely dependent on the recovering economy, which we're all so proud of. So on that basis, I don't propose to accept this amendment and do a special once-off review, because we do an annual review on all of our payments in the department.
Senator Arda, has the amendment being pressed? Yes. The question is that a new section will be there inserted. Those in favour say "ta." Those against say "nil." And the question is defeated. Vote all. Take your designated seats. Social Welfare Bill 2017 Committee Stage Amendment 8 in name of Senator Catherine Arda. The question is that the new section be there inserted. On that question, division has been challenged. Tellers Toss, Senator Catherine Arda and Senator Paul Daly. Neil, Senator Gabriel McFadden, Senator John O'Mahony. Time allocated for vote is 1 minute starting now. For voting. signed by the four tellers is 14 each, and there is an equality of votes, and I have therefore, pursuant to Article 15, 11(2) of the Constitution, exercised my casting vote. I vote against the question, so therefore the result is Neil 15, Thaw 14. The question is defeated. The next one is amendment number 9 in the name of Senator Higgins. It's a new section. Welcome the Minister back to the chamber. Oh, you're here. Oh, no.
We're now on Amendment 9. In the name of Senator Higgins. Are you moving?
Yes.
Are you moving this, Senator Higgins?
I'm moving the amendment number 9 in respect of voluntary labour activation, and I just should indicate that it has relevance also for amendment number 12, which is in respect of qualified adults. There is a concern, Minister, that in recent years in particular, but also that we have had a very, very strong focus, and not just actually only in recent years, but also historically, that Ireland has such a strong focus on the live register and the need to ensure that the figures, or the political, in many cases, demand to ensure that the figures on the live register are moving and changing, that there has been, I believe, a neglect of the question of those who are not on the live register but do want to access employment, training or education. Far too often, and I have had in my previous life with the National Women's Council of Ireland, I recall coming into the Committee on Social Protection and very much getting the sense that those who are facing potential sanction on the live register in terms of accessing employment would always take considerable priority, and that there was a sense that people needed to wait. In recent discussions at that committee, we've had a sense that now we might be able to afford to give a little bit of a support to those seeking voluntary activation support, be it education, employment or training. And I do have to regret that this approach has been there for this period of time, because while we might say now we have the resources to do it, we do have the fact that for many people, a 3 or 4 or 5 year period of their life, which could have been engaged in training, in education, in employment and actively, they were not supported to do that. And this is people's lives and people's opportunities that we are talking about. I think that the emphasis on those who face sanction and are being compelled to seek activation has sometimes caused us to neglect those who may voluntarily be very, very interested in accessing supports, but may have some concerns around the system. For example, the fact that still in our system we require full-time availability. And I think this can act as a disincentive to those who may want to start building labour market attachment, who may want to start working part-time, who may have caring commitments or may have diminished capacity, for example, but who want to start engaging with employment. So there are concerns here, Minister, in that regard. What I'm asking you to look at is how, not just that in principle that there is access, because I know I've been told often that in principle there is access to Intrio and local employment services, but to ensure that we have effective access and effective voluntary access and support for those who voluntarily are not on the live register but who voluntarily wish to get employment, to seek employment, activation and support. The groups and cohorts who I'm thinking of in this in particular are those who, for example, are on one-parent family payment, but who may wish to access employment and training opportunities prior to going on job seeker transitional, may wish to access that on a voluntary basis. And I believe, we've discussed previously in terms of lone parents, I believe there are far more who would like to access supports and who don't need to be pushed but need to be supported. In terms of qualified adults, people who are very much invisible within our social protection. In fact, not only are they distant from the jobs market, but they are distant from the social protection system and the employment and activation supports. In many cases, we don't even chart fully the information about who these people are and what they might be interested in, and they can disappear from the register and from the system. And, of course, those who are on a disability allowance, and that is, I think, a longer discussion, Minister. Perhaps it's one that may be discussed. I know my colleague, Senator Dolan, is engaged actively with it, and something he may be bringing forward as well in report stage. But that question of those on disability allowance and ensuring, because we've had, for example, high-quality schemes such as the Job Plus scheme, for example, to pick one, but there are many other high-quality schemes which were explicitly not available to those not on the live register. And one of the most striking, and I found quite heartbreaking examples of this, was in terms of the European Youth Guarantee, when it rolled out in Ballymun, which has had a large number of lone parents who were not able to, who were under the age for the European Youth Guarantee, but who were not included in that pilot project in terms of being allowed to access the employment, training and educational opportunities under that pilot scheme, because the European Youth Guarantee was targeted towards the live register. So again, these are people who are falling by the wayside. I know, Minister, that you have an interest in this area, an issue. So what I'm trying to suggest in this report, and I won't speak so extensively on amendment number 12, because I think it touches on very similar issues, is how we can make access and support a reality for everybody who wishes to seek it on a voluntary basis. Thank you.
Minister.
Thanks, Senator. I think the focus of the employment services provided through Intrio is to support and assist people who are going back to work in whatever shape that happens to be appropriate for them. And the Intrio services are already open to job seekers. And actually, since our conversation last night, I've checked, it's irregardless of their status. So a lot of the people that we currently help are not on the live register. Employment services provided by one of our contracted services, which is the local employment services, the LESs, has a similar focus specifically in relation to people who are not on job seekers, including qualified adult dependents who can and do avail of the service on a voluntary basis. However, it is acknowledged that many people have educational or training requirements which need to be met before they probably could successfully complete or compete in the labour market. And in such cases, the staff of Intrio or the LESs will work with the individuals to identify and address those needs as part of the process of agreeing each individual personal progression plan to nominate the person for training within our ETBs or other training providers, as obviously is the person's wish. A range of activation programmes, particularly in the area of education and training, are available to any job seeker, irrespective of their live register status. In line with long-established policy, participants on these programmes receive allowances in line with their previous welfare payments, and this means that persons who are not in receipt of welfare payments obviously don't get the allowances, but it still means that we will engage reactively with them when they come in and they want, obviously, assistance. And the funding model for wages on temporary employment programmes such as community employment or TUS is based specifically on the generation of savings as a result of participants moving off prior schemes onto these other schemes. So it's not feasible to alter this funding method for people who are not in receipt of a social welfare payment for them to go on to C schemes or TUSs. Can I also just point you to the area of two specific proactive measures? So up until this point, our Intrio services, our LESs, our jobs clubs all work reactionary when people come in who are not on the live register looking for our assistance. But there's two specific things that we're doing this year. We launched the Jobless Households Action Plan, and we also have the Ability Programme for people with disabilities, whereby our staff will proactively go out and seek out people who are in jobless households, who are not in receipt of social welfare payments within their own rights, and most of those people are the qualified adults that we're talking about, who receive payments through their spouses. But specifically go out, target those people to try and get them to engage with our training, our education, our work experience programmes. And the Ability programme is specifically designed to address those issues for people who have either an intellectual or physical disability. And we're working with NGOs and service providers to roll out a programme for specific actions and plans to make people who have disabilities job ready, so that they then can move to stuff other social welfare payments like the partial capacity payment or part-time work, which is effectively obviously what we want to do. The purpose of any of the activation programmes that we carry out is with the view to getting people who are unemployed, employed, and people who are underemployed into full-time employment. So the reason I'm not accepting the amendment is because I actually don't think there's a reason to accept the amendment, because what you're looking for is already the practice within all of our local offices.
Thank you, Minister. Senator Higgins.
I would say that while it may be there in principle, I don't believe that we are seeing effective access in practice in many cases. And I know that I've heard of many instances where people have not been able to be accessing full support, or, for example, have been told that it will require them going on the live register and indicating full-time availability, which in some cases they may not be able to do. Or they have been told that it's simply not a priority at this time, or they've been indicated a very basic version of here are leaflets and here is a website, but not afforded the kind of casework, particularly around areas, for example, such as like back to education and other programmes such as. So it may be there in principle, but it hasn't been there in practice. However, I do accept and acknowledge, Minister, what you have said, that you are now seeking to take active measures in terms of the piloting in relation to the jobless households. Though again, of course, the intrinsic right to be supported in terms of activation and employment is a right of the person and shouldn't depend necessarily on the status of their household or their partner. But I do recognise it as a step forward, and I hope that the learning from the pilot may in fact lead to a further extension of supports. And I'd like to just clarify, Minister, this piloting in terms of the work on jobless households, when do you see us developing learning from that and being able to see how it might be strengthened or rolled out further? And also, can I confirm that it is on a voluntary basis and it is not on a basis of compulsion, in terms of there is that difference between encouragement, of course, and compliance. So we want to be able to give people encouragement and support to effectively invite them, that they feel they can walk into the Intrio or LES office or whatever it may be. But I don't believe that coming in with the fear of sanction or the fear of loss of payment or the fear is the way to go. So maybe if you could confirm that that's not the approach.
Go ahead, Minister. Yeah.
Well, completely put on the record. The Action Plan for Jobless Households, the reaction in all of our LESs, our Intro office or our DESP offices is all on the basis of people voluntarily participating. The pilot in the Action Plan for Jobs is being done on 5 regions, and we'll probably do it for about 6 months before you'll be able to see real quantitative data. Now, actually, in my experience, and maybe you'll bear this out with me, when you're offered assistance, people grab it with both hands. Like, they don't put up resistance to you and tell you, no, I don't want to do a course or an educational qualification course or anything like that. So I actually genuinely think that we'll get a very positive response from the people who are not listed in any scheme currently other than a dependent spouse from a person in a house who is already receiving a social welfare payment. But I won't really know until maybe 6 months has passed. So we're kicking it off in January. There's 5 specific regions around the country that we're doing it in. And then maybe when I get the results back, we might come to the JOC, have a look at the results. I would anticipate that it's going to be a success, obviously. And when it is a success, then we'll roll it out to the rest of the country. But maybe we'll talk about it to tweak based on the evidence that we have coming back after a couple of months.
Okay. Thank you, Minister.
And thank you very much. And on the basis of that, I'm happy to work with the Minister through the JOC, the Joint Committee, and I will be withdrawing the amendment for now.
Okay, is that agreed? Agreed. Okay, so the amendment is withdrawn by agreement of the House. Amendment number 10 in the name of Senator Higgins.
Yes.
Will you move it?
I move the amendment. Minister, this amendment seeks to set forth guidelines in respect of something you mentioned yourself, personal progression plans, but specifically in terms of those personal progression plans and how they are used not by the department itself but by a third party contracted by the department in respect of labour activation. So in particular, I'm thinking of those contracted agencies, TUS and not TUS, but sorry, Thuras Nua and CTAC, who have been contracted in respect of the Job Path programme. And the guidelines which I'm being asked to be drawn up, and perhaps there may be another way to ensure that these issues are addressed, but the guidelines that I am proposing to be produced touch on a number of issues of concern which have been coming through in respect of how Job Path is operating on the ground, and in terms of what requirements are being made of persons in terms of personal progression plans. Of course, you know, it's positive if people are given the opportunity to develop a plan and to look forward and to plan for their future. However, it has been indicated that we've seen indication that there's inappropriate language in the personal progression plans which people are being required to sign in order to indicate that they are cooperating. Because I agree, I believe, like you, Minister, that most people will seize opportunities and do want to seize opportunities. But what we have seen here is that where somebody simply won't sign a particular piece of paper because they have, I believe, some legitimate concerns about the language on that paper and what it binds them to, they are being regarded as not cooperating, and that the activation and employment process doesn't proceed effectively. So the 5 key points I want to highlight are: it is very important that a person is offered options. And we have heard that people often feel, again, this may be practice rather than policy or principle, but don't feel that they are given full options in terms of education, training and employment. That many cases people who have engaged with Job Path have felt very strongly pushed towards a particular option or a particular employment option, rather than feeling that they have been able to consider fully those full. So that is a concern, again, in practice. The other requirement, a suggestion, is we have heard of persons who are being given the personal progression plan and asked to sign it before they are allowed to take a copy of that plan. For example, to seek advice, to look to it, to compare it with others, to discuss it, to seek legal. And of course, it's extremely poor contract practice that anybody would be asked to sign a contract before they are given a copy of the contract to take away. So that's a key concern. Again, I'm seeking to address these issues because they are issues that are happening in practice. Minister, there may be other ways to address them, and maybe they're not there in principle, but we do need to, give credence to when we are hearing it coming through from a number of sources. C and D, and in fact E, are all the same linked point. And it comes back, Minister, to the General Data Protection Regulation, which we discussed extensively in terms of the public service card. It comes back to the question of people being inappropriately compelled to give information that is not necessary to the task at hand. And this key question here is, I have seen at least text purporting to be within at least one instance of personal progression plans, and I believe I've heard that it may be standard, text which requires an individual to share data in respect of family members or cohabitees, so to report any change in circumstance for their spouse or for themselves. Again, while all these issues may be discussed in terms of casework, if these companies are contracted simply to provide an activation and employment support for an individual, they are not payment agencies, and we have often been reminded very extensively that they are not payment agencies and they are not sanctioning agencies. It would not seem to be appropriate that they would be, that the person would be required to give information about another individual who they may be living with, a spouse, or who has their own relationship, for example, with Intrio, and may or may not even be in the Job Path system. So there's a real concern about that information being required as a sign of cooperation. And the other concern that we have is text which requires individuals to agree to share contact information and permit contact in respect of an employer who they may have sourced outside, entirely separate from the third party. So if somebody is there in Job Path and they go ahead and they find a job on their own, maybe they get their dream job, or maybe they get a job that they've wanted, with a small business. It's simply, the simple relevant information is simply for them to inform, of course, the Department of Social Protection that they are now in employment and no longer need job seekers allowance or assistance. I cannot see why it is either appropriate or necessary for them to inform CTAC or Thuras Nua not only of the detail and contact details of their new employer, but to permit contact with that new employer, because they simply are no longer requiring the services of CTAC or Thuras Nua. And we have heard instances in the Dáil, Deputy Murphy, I think, has highlighted in the past, situations where we have heard of CTAC and Thuras Nua contacting a new employer that someone has sourced on their own and asking them to sign paperwork to indicate how that job was sourced and that it was sourced through CTAC or Thuras Nua when it wasn't. We can only imagine how difficult and in some cases I'm sure embarrassing it is for individuals to have their first week or two in a new employment overshadowed by contact from a delegated third-party company. And it's not the right way for anybody who has had the initiative to go and find a job themselves for their new employment to be beginning. So, Minister, if you could address, these are the concerns. I've proposed one way to address them. You may have other ways to address them.
Go ahead, Minister.
Thanks, Chair, and thanks, Senator. First of all, a personal progression plan is an organic document, and it's personal, obviously, to the individual job seekers. I can't say this in any more strenuous terms than I'm going to say. It is not a contract, and it is not a legally binding document. It's a progression plan for somebody who's out of work to get them into a position of where they are in work. It's literally as simple as that. And it isn't, I know you've made reference to it, but you're not on your own. Loads of other people have made reference to it as well. They're not unique to Thuras Nua or CTEC. They happen to be two agents that are operating for us around the country. But exactly the same personal progression plan is conducted and developed with somebody that's availing of our Intrio services. So if there's a criticism, then the criticism cannot be confined to just CTEC or Thuras Nua, because there are as many personal progression plans that are availed of through our Intrio offices as there are elsewhere. And can I tell you that it's a plan that's developed in consultation between the job seeker and the advisor, whether they happen to be an Intrio advisor or an agent advisor. And it's supporting and an enabling document that hopefully will map out that person's journey to either upskill, to get barriers to employment that they currently might have in their life, getting rid of them, and to find pathways to a job for the individual that's getting one-on-one treatment with the advisor and the job seeker on a weekly basis. And that's what the provision of the activation support is supposed to be all about and is all about. It's about working closely with the people to make sure that we get the best results for the individual based on their current circumstances. And the laying down of such prescriptive and restrictive guidelines, I think, as you're suggesting in the amendment, would be, I believe, contrary to the engagement that is the policy between the personal advisor and the job seeker. And it might get in the way of what's supposed to be a genuine, mutually developing relationship between the two people over the course of whatever length of time, up until 12 months, that that person is engaging with that advisor. And I think it's important to note, at the time of their making the claim to be a job seeker, whether it's in an Intrio office, a local DSP office, or having been sent onwards to CTEC and to Thuras Nua, through an agreed record of mutual commitments, that all of the information that you're concerned that people might be being compelled to give, we're already aware of it. So in order to make a job seeker's claim, we already know who you're living with, how many dependents you have in your house, what your circumstances are. That information has already been shared. And the absolutely only reason, because there's absolutely no requirement at a personal progression plan stage that you have to share that you have 3 kids and your granny is living in the house with you. You know, the only reason that those conversations should take place is because your circumstances at home may form a barrier to employment or may form a barrier to progressing a pathway to work. And it's only about general concern and conversation with each other that we might inquire how old your kids are, or do you have a dependent spouse at home, or is your elderly relative. It's a general conversation of sharing of agreement, sharing of data that actually we already have in, I suppose, what we call HQ for argument's sake, right? But also just to absolutely be really clear and straight with you. If you don't want to share that information with your personal advisor, then don't. And there is no part of the personal progression plan that says you can't move to part B if you don't tell me. It doesn't exist. It's generally only a form of part of developing the relationship with each other and to learn from our perspective, from an advisor's perspective, what are the barriers to our job seekers achieving full employment. And a key element of the Modern Activation Service, obviously from our perspective, is to secure full employment or fuller employment for people who are in part-time work. And the personal advisors, their sole job is to be your conduit from not having work to getting work. And again, I stressed this to you last night, the only reason, there's two reasons now, that if you do and have the initiative enough to get jobs outside of that personal progression plan that you might have with your advisor, first of all, we'd want to know who it is, right? But not with a view to contacting the employer. And I think there's a misshapen view out there that unless we know who the employer is, that Turas Nua and CTEC don't get paid for the placement. They get paid anyway. They get paid if we don't know who the employer is. They get paid once somebody who's on JobsPath gets a job. If that job happens to be in Outer Mongolia or up in Superquin in Finglas, they get paid anyway. The reason that there's the continuation of the cooperation is that we provide ongoing in-work support to the advisors, because sometimes, and this is borne out by practice, people have developed such personal relationships with their advisor, and in a lot of cases when somebody does get a new job, it's having been out of work for a long time. Their confidence mightn't be as high as you'd expect them to be. They're probably vulnerable and nervous, and we provide those in-supports or in-work supports to make sure that you know that your advisor is there at the end of a phone call, but also once a month your advisor is going to touch base with you to say, how's it going, any difficulty, have you made, settled in and made new friends. It's what you would expect for two people who have developed a relationship over a number of months, up to 12 months. So I want to emphasise to the House that the Department's public employment services, including Turas Nua, CTEC and our own Intrio offices, operate in full compliance with the data protection legislation, and all of our contractors are aware of their current obligations under the GDPR. And obviously, as we change, as we've suggested earlier on, when the new regulations come into play on the 18th of May next year, all of our contractors will have been given strict new guidelines that they will have to adhere to on the basis of the new directive coming into play on the 18th. And because of that, and I hope you're reassured, but because of that, I think it would be unfair of me to put such prescriptive restrictions that don't apply or definitely shouldn't apply to the policy or the practice that's carried on on behalf of us of any of our agents, but also because of our Intro offices do the same thing. I think it would be too prohibitive to put them in as an amendment to the legislation. But I do want to say to you, because I know I listened very carefully to what you said when we were here during second stage, of anecdotal evidence, right? And there's lots of anecdotal evidence that's brought, that some of it may be grounded in truth and some of it is not. If you genuinely have somebody who has experienced what you said in the second stage speeches to me, please bring the information either to me or to somebody in the department, and I promise you we'll follow up on it. Because if the policy is different to the practice, well then I want to know about it and make sure that all of our practices adhere to the policy commitments that we have.
Thank you, Minister. Unfortunately, I think that there is sometimes a shortfall between policy and practice, and of course there is a slight difference. Of course, personal progression plans, nobody's against them as a concept, and they are in practice in a number of different areas. I think what is specific here is that it is third parties, so it is a little bit different because they are only contracted for part of the process, whereas the question of payment and sanction still sits with what you've described as HQ. So that's why the question is that in terms of what information is appropriate to be shared with the third party who is not contracted in terms of payment or sanction. That's why it comes in a little bit, and why I was calling for that additional scrutiny in that regard, because of course personal progression plans have been used in practice for a long time, but it is a matter of just ensuring good practice. I will take the Minister to Fides that she would tend to, I would encourage her to, if we get, rather than a case-by-case basis, that if you begin to get a number of cases sent, that you will also look, and maybe if the department could reconfirm and recheck in with around what you said today. So, for example, with those contracted parties or third parties, because can the Minister confirm that what you are telling us today is that no person should be subject to a sanction from the Department of Social Protection because they have refused to sign a personal progression plan which contains the kinds of information in C and D without their agreement? It shouldn't happen. So that's to confirm that. So because that just makes it clearer for others who may not.
Sorry,
because to make it clear, because so that because individuals may contact me, but I think it's important and useful to send a signal to all individuals who may be undergoing this process.
Well, then let me, through the Chair, confirm. First of all, the personal progression plan, it isn't a contract, it's not a legally binding document, it's not something that can be forced. It's supposed to be an aid. It's supposed to be a pathway from getting somebody who's unemployed to being employment. There's already a legal obligation on a job seeker to inform the department of a change in circumstances. It's not like we're trying to find out that you're actually living with your rich Auntie Mary. If you are living with your rich Auntie Mary, you're obliged to come and tell the department through the job seeker's payment that you get anyway. The only reason there might be a curiosity, because it's not a requirement of the progression plan, there might be a curiosity on behalf of your advisor to know what are your circumstances so that he or she can learn what barriers actually exist in your life. But can I just hopefully reassure you, right? I'm not the type of person that gets told something by somebody and thinks it's gospel, right? So for the last number of weeks, 1 day a week, every week, I've gone to an Intro office, I've gone to a CTEC or a Tourist New office to see for myself. And it's not to talk, right, I have to talk to the staff and they're all lovely, right, to be very honest with you, they really are. But actually I'm more concerned about speaking to the people who are sitting on the other side of the desks. And this week I was in Kildare, last week I was in Longford, the week before I think it was Athlone. I'm going and meeting these people so that I can be categorically satisfied that when I stand in front of you and tell you I see good stuff happening. And that's not to say we've tens of thousands of people. You're always going to have somebody that doesn't have a pleasant experience. It might be a personality. We have to deal with those on a case-by-case basis. But in the main, first of all, we are providing real opportunity and progression for people who are going through job path. And we've witnessed a young fella given his advisor a Christmas present wrapped up with a pancetta and a box of chocolates the other day. And not to be smart or dismiss it, when somebody is living on 198 quid a week, that's a lot of money to take out of their own pocket to show an appreciation of somebody that is genuinely helping them. So the purpose of us doing this is to help. It's not to provoke or prod or peeve people off, but just to be absolutely categorically clear. It's not a legal binding document. If somebody wants to take it home and talk to their mother, their friend, their partner about what's in the contract, what's in the progression plan.
And suggest amendments if necessary.
Yeah, absolutely. But it's all about helping the person. It's not about being prescriptive, because no two people and their pathways or their barriers to work are going to be exactly the same. So just to let you know, I keep visiting the offices, and if there are specific cases and they do come in numbers, of course I'm going to look at them, because what I don't want is anecdotal talk maligning something that actually is genuinely helping people. So on that basis then.
Okay. Senator Higgins.
I thank the Minister for her hands-on engagement on the issue. I'm not going to press the amendment for now. I'm withdrawing the amendment for now, and I hope we will be able to look at the issue in the future.
Agreed. Thank you. Now we move on. Just for the benefit of members, we have 6 amendments left, all in the name of Senator Higgins, and we must conclude by 5 at the very latest. Senator Higgins, amendment number 11.
Amendment number 11. This is in respect of an issue which I previously highlighted at second stage to the Minister. I move the amendment which I previously highlighted at second stage to the Minister, which is the concern that in the way that we currently calculate availability for work, it may, for example, make it be different. People who may well be absolutely seeking full-time employment, however, if they are offered, for example, a 2-hour job for 5 days of the week, if they're offered a job between 10 a.m. and 12 p.m. every day, they face the danger that by simply taking that job, they are marked as being fully employed. And again, it comes back to that full-time availability notion. So, for example, people who have the opportunity, and it doesn't exclusively at all, but it does also affect particularly women or any other persons who have caring responsibilities and others. If they got a full-time job, they may be able to afford childcare. If they don't get a full-time job and they're offered a part-time job, then the problem is, if that part-time job is a number of small hours across a few days, they can find themselves falling out of the trap and in a bit of a bind. And I think it can close off some opportunities for building of labour market attachment, building working relationships, etc. So it's really addressing that question around hours versus days, in terms of can we do it in a more effective way, in terms of ensuring that we are supporting people who may be getting part-time work on their way to full-time work.
First of all, we recognise that the labour market is actually changing, and we're moving away from historical, traditional working patterns, and we've a whole new gig platforms, platform economies, a whole new, I suppose, way of working that we never had before. And obviously all of our activation schemes has to be reflective of that. So I'm going to ask you to withdraw this on the basis of, there's two reasons why I don't want to do it specifically on its own, right? But I will ask you to withdraw it on the basis of that there is an amendment that's before you that was made in the Dáil for me to currently review the working family payment system. And what I'd like to do is to, in its totality, look at the hours-based system, the working family payment system, how to see we can best merge the two. Because I think if I look at the hour system on its own, we're going to end up right back at zero, and I'll tell you why. The introduction of any changes to the current criteria for calculating entitlement to job seekers' allowance, as in moving to an hours-based system, will result in significant numbers of individuals becoming eligible for job seekers' payment. And that obviously is going to cost tens of millions of euros, right? And then it's also important to note that if an hours-based system was introduced, there are existing casual job seekers who will lose out on payments that they're currently receiving from the department, and that might save us tens of millions of euros. But actually, whilst we might be helping people over here, we'll be hindering people over there, which is not, we never want to do something good to cause an anomaly over there, right? So what I'm asking you to do is that will you let me, in the review of the Working Family Payment Scheme, have a look at how best, I know you don't want to hinder the people over there, but I know exactly what you want to do with regard to helping people who are only have the capacity to be able to work for a small number of hours, but can't live on fresh air for the rest of the hours that they're not available to work. So let's have a look in that review how I can address the issue that you're specifically looking to try and address. And maybe it'll be by widening some of the working family payments that we have, so as the current 19 hours, 15 hours. Let's have a look at that in that review, and I'll bring that review back to the JOC, and we can talk about the results of that as to how best then to prepare. Because again, not to be smart, if we are going to do something around this, it can only be done in the budgetary process next year, which we'll start after the summer. Or maybe even before the summer, depending on how much of our workload is. So, just to ask you to consider it.
Thank you, Minister. And I do recognise that amendment, the amendment from Fianna Fáil that was accepted from Deputy OD in terms of looking at the family at the working family payment, and I also note the fact that you've indicated here and previously that you're going to be looking at the question of the 19 hours. And at second stage, I highlighted my concern around the anomalies between the 15-hour childcare and the 19 hours. I didn't put forward an amendment on that because I think you recognise that issue, and it's probably already within the remit of this examination. And I will accept your proposal to examine this issue that I've raised here within the context of that wider. Of course, there's no point in us duplicating, and it will be more expeditious, I imagine, if you were to consider it in the context of looking at the working family payment. Thank you. So I withdraw.
Withdrawn. Is that agreed?
Agreed.
Agreed. Now, next amendment is number 12 in the name of Senator Higgins. Go ahead.
Yes, I spoke extensively to the points in number 12. I moved the amendment. I spoke extensively to the points in this when I spoke about amendment number 9, and I think there was some overlap, so I won't reiterate my key points. But again, it was that question of qualified adults, and it was really a proposal in examination of this issue. And it may be a little bit. This is a little bit maybe wider than simply the jobless families, because I would also highlight there's another little group who fall in here, which is situations where, for example, you have somebody who is retired, and they have a qualified adult spouse who may still be of a younger age or something. So there's kind of a few cohorts there. But I appreciate that you plan to examine it as part of that pilot, and I hope this issue might be teased out. Specifically, I'm looking to say, can there be learnings from the job seeker transitional payment in terms of, which is in itself in a process of improvement and needing to be improved, but in terms of that kind of targeted casework, looking at the other supports like childcare supports and other supports that somebody who is a qualified adult might need in terms of ensuring that they can access activation opportunities, and the questions in some cases of job readiness, of skilling up, if somebody is going to go back into education, so they become almost education ready as well as employment ready. So really just to suggest that that might be looked at. And also again, and I know I'm a broken record on this issue, something that is positive about job seekers transitional, it's something I think we need to examine fundamentally, is the requirement for full-time availability. Again, that waiving of that in the case of job seekers transitional was quite positive, because it gave people the freedom to actually talk about options, to talk honestly, as you described, and I hope they will get to do it with caseworkers. That's not what I'm getting at with my previous amendment. To talk honestly about how they are trying to balance care and opportunity. So again, just to suggest we might take those learnings into that examination that you've already indicated. I won't be pressing the amendment.
Yeah, but I totally agree, and actually I would hope that that will form part of the report that we bring back to the GRC, and we could talk about then what's the
So you're withdrawing it?
I withdraw it.
Okay, is that agreed?
Agreed.
Okay. Now, Amendment 13, Senator Higgins. Are you moving it?
In respect of number...
Are you moving it?
Well, actually, I need to move it before I withdraw it, don't
Yeah.
I? I'd like to move it, but I'm actually going to withdraw it because my colleague, Senator Ruan, I know is very keen to discuss this issue with the Minister. I know she has been in discussion with you, Minister.
Move it just to talk about it.
Okay, I'll say I move the amendment.
Okay.
It's in respect of a national maintenance body. As you will be aware, the Joint Oireachtas Committee and Social Protection, we put forward a very strong recommendation in our report on lone parents earlier this year, Minister, very strongly suggesting that we need to look in Ireland at the potential options around a national maintenance body. We highlighted the flaws, and I know that you've spoken separately in this chamber and others about the falling down and the flaws that happen, whereby we have really practices that are not appropriate in terms of women, in many cases, not always women, but also particularly women, mostly women, having to seek spouses and having to really pursue in terms of maintenance, and having a fear that they may, in fact, lose their payments or see a reduction in their payments if they are not seen to be very actively seeking maintenance payment. And we know there was a very unfortunate moment in the history of the Department of Social Protection a few years ago where they sent out that letter informing people, but when we brought in job seekers transitional and moved from one-parent family payment, but informing effectively a number of spouses that they would no longer be watching to see about payments. And the way I think that was done and framed was very, very unfortunate, because it sent a very negative signal in terms of maintenance. We've kind of had historical, I believe, mistakes in it. I feel we have practices that are not working at the moment in it. I'm not going to enumerate it in great detail, Minister, because I know it's an issue of great passion for my colleague Senator Ruan, who is currently in the 8th Committee. So I'm going to be withdrawing it and moving it again at report stage, and she will be speaking to it at that point.
Okay, well then, would you
Well,
want
the Minister
to withdraw?
can give a sentence if you want.
I presume the Minister will have to address it all again when we deal with it.
Tomorrow.
Yeah, if you withdraw it and reapply for it tomorrow, we'll have a proper conversation.
So you're withdrawing
Yes.
it? Is that agreed?
Agreed.
Agreed. Okay. Now, Amendment 14, Senator Higgins.
Yes. Amendment 14 is in respect of a very...
Sorry, 14 and 15 are related and may be discussed together by agreement. Are you happy to discuss 14 and 15 together?
Okay, 1 second. I would actually query if they are related, but I'm happy to discuss them together nonetheless, because they do both relate to lone parents. But I think, of course, the key concern is...
So it's agreed to discuss together?
Yeah, why not?
Okay,
but just to clarify, I think one of the key problems is, in terms of, to speak first, in terms of Amendment 15, is around job seekers' transitional payment. One of the key concerns is that those who have a child over 14 don't have access to the job seekers' transition, and they are not part of the job seeker transitional payment supports. And again, so I'll speak first to 15 and then to 14. I think it will work better. So in terms of 15, I spoke previously, Minister, about the job seeker transitional payment supports. There are still concerns, and there's still concerns. I know there's been partial income disregard restored, and others, in terms of some of the financial loss that people experienced in moving to job seekers transitional payment. But what I wanted to focus here was a little bit the wider question of supports attached to job seekers transitional payment. And there is a concern, again, and this comes back to that question of casework, there is a concern about whether the full gamut, and an appropriately full and rich gamut of employment, training and educational opportunities are being offered to those who are on job seekers transitional payment. Again, we're moving in because we have that waiver of full-time requirement for availability, but we still don't have an adequate or wide enough range of part-time courses and part-time education and part-time training support. So, in one sense, for example, the question of people who might want to go back to education but might need to go part-time. So how can we ensure that if we are introducing this new payment, and we have introduced it and people are on it, and this, with a new set of criteria, that we also have an appropriately tailored set of both tailored supports on one level, as I say, those, for example, which recognise potentially constrained time availability, but also access to the full range of the wider supports that are there. Because, and I think you spoke to it very eloquently at second stage, Minister, there's no reason why somebody who is a lone parent who is on job seeker transitional may not want to start a 5-year course to become a physicist in a senior way, and why that should not be one of the options that is there on the table for them, rather than being bound into a very constrained set of options which is there at the moment. So it's really around improving that work, Minister. Even as this area needs to be improved, the problem for those with a child over 14, and I speak now to Amendment 14, with a child over 14 is they don't have access to any of those particularly tailored supports. The idea of caseworkers who will be working with them, recognising in particular their care balances, recognising that in some cases somebody is absolutely full-time available, in other cases they may have a 14 or 15-year-old who is facing any kind of challenge and may not be able to. They may not feel that they are able to work full-time because they are parenting alone. They don't have that safety net, that backup person, that sharing of holiday time and pooling it over the year or whatever else families do to try to manage. And we all know that every family in Ireland, not just lone parent families, they are often juggling. Families with teenagers, they're juggling, they're balancing, they're figuring out how to make this work. And the challenges faced by a lone parent, somebody parenting alone with a teenager, are very, very high. And there are two concerns here, Minister. One is in terms of the qualified child payment. I recognise there was a small increase in that, and I know, and I'm sure you would acknowledge, it's very inadequate, in terms of that increase in the qualified child payment. But there's a specific need for increase in qualified child payments for those with for children over the age of 14. And we know that from the Vincentian Partnership research, which gave us, very deeply calculated, and I think it's actually incredibly laudable research. I think it's something we should, we could be very proud of, as the research which really looks at minimum essential standards of living in great depth and detail. And we know that there are huge costs and higher costs for a teenager. The other issue, Minister, is that question of this additional supports, childcare supports, tailored options that people might need. So what I'm hoping, I know it's not at the behest of you to do in this bill, but I will be revisiting it over the year ahead, is that we should be able to look to a point whereby anybody with a child under the age of 18 who is parenting alone is able to access job seeker transitional support. Because I know there's my last comment I will make in it, I know that there's also, it's something that can be quite upsetting for people, because people feel the fact that they're parenting alone becomes invisible to the system once their child hits 14. They're just a job seeker. They're just going in for the job seeker's allowance. They're no longer recognised as somebody who is parenting alone and facing those particular challenges. So, Minister, if you could address either of those amendments, would be.
Okay, Minister, go ahead.
Can I go backwards, right? Because, well, actually, the QCI one is probably easy. So we do Amendment 14. I totally recognise not just what you've said, but also what NGOs have said, that it does cost more money to raise teenagers. I have a few of them at home, right? So we know that they go around with their hand open all of the time, and that they grow out of clothes much quicker. So I don't need to be told. I would have loved in this year's budget to be able to reflect and recognise that, but because of the way the budget negotiations were structured and the amount of people that we had to look after, there wasn't a huge amount of money left over to do specific policy measures, right? So you do know that the QCI increase this year was the first one in 8 years. It was only €2, which isn't enough. But had I reflected the over 12s and under 12s, I would have ended up giving €3 and €1, or €2.50 and €1.50. And I actually thought that the money was so miserable in the first place, But that's not to say that I don't recognise what you've said. I do, and that in next year's budget and the year after's budget, what we will do is to reflect the reality that having teenagers does cost you more money, right? So I can only give you my word on number 14, as opposed to putting it into an amendment. And the second thing I'll say to you is that two parts to this, right? First of all of the services that are available to people on job seekers transition. First of all, I think we need to reflect on when we brought it in, that some of those people that we didn't get to their children might have already become 14 years of age and gone on to job seekers allowance or benefit before they got to avail of the full range of services that were specifically designed for lone parents between their children between the ages of 7 and 14 to upskill, up-educate themselves. I'm going to make sure that we do an analysis to make sure that if people have gone into the next level and didn't avail of our services, that we proactively go after them, but also that we proactively make sure that we reach all of the 32,000 lone parents that are in the JSIT umbrella, to make sure, I think we've only reached 60% of them to date so far, that we make sure that we get to the rest of them before they transit to the next job seekers allowance. But I'll also say to you for two other things, that just because somebody goes on to job seekers allowance doesn't mean that we should treat them any differently. We still should recognise the limitations that they have, the concerns of care that they have at home. There's a lot more children that present with difficulties over and above what would have done 10 or 15 or 30 years ago. We need to recognise the barriers to work, and that comes back to then to the personal progression plans that people have with either in our inter offices or our agents. If we're not fully aware of the barriers that exist in people's lives, then we can't plan around them to help you become job ready and to become employed. But also, and this is what I'm absolutely adamant on, there should be no limits to women in the main, or men who are parenting alone, who want to upskill or up-educate themselves. I'm sorry, this business of only having 20 courses that you can go on and the rest of the world, you know, is closed off to you is not acceptable to me. So I'm going to come back to you in the next couple of weeks with a complete list of what is available, both either through e-learning or through our educational courses. And if we don't like the look of it, which I know we mightn't, right, then we're going to change it. So I can only give you again my personal commitment that that's something that's going to be changed by me.
Okay, thanks.
Thank you very much, Minister. And I think you are right. There are many who received the shock of moving from one-parent family payment to job seekers allowance without any of the supports. And I think it's important that they be addressed. And I do recognise the importance of the casework and tailoring and recognising needs. I have the concern that the full-time availability tool can sometimes be something that makes it hard for people who are on job seekers allowance to talk honestly about those issues in terms of casework, and that's a concern. But we can put that to the side for now. And I very much welcome your agreement to provide me with a list of the schemes that are available, and indeed it would be very useful if it was agreeable to you to be able to share that with the Joint Oireachtas Committee, because we are currently preparing a report on activation, and it might be a useful issue to incorporate or to reflect within that.
Give me 1 second, how quickly can I get that? Can I get that? We'll get that to you by the end of January, right?
Thank you very much, Minister.
Into what we're going to do next year.
Thank you, Minister.
Okay, in that
Thank
context,
you,
I will withdraw my amendment.
Okay, so just for the technicalities of it, I'm not absolutely sure you did move 14, so move 14 first,
I move
please.
14.
And now, are you asking to withdraw it?
I withdraw 14.
Is that agreed?
Yeah.
Okay, and now we move on. Amendment 15, you need to move
15.
it. And then you need to withdraw it.
And I withdraw it.
Is that agreed?
Yeah.
Thank you all. Now, last amendment, number 16, Senator Higgins.
Okay, nearly done. So, amendment 16. So in Amendment 16, and Minister, I should let you know that I had a similar amendment, which others in this House have spoken about before, in respect of the Department of Finance. So it's not I'm not simply putting this issue to yourself, and it's not simply targeted at the Department of Social Protection. What I'm really trying to highlight here is, and I know that you have agreed to a report on the state contributory pension in terms of reviewing the question of the 2012 changes, their impact, and no, you haven't previously? There is a report mentioned in terms of an amendment from the Dáil.
There's an amendment from the Dáil, sorry, to the Chair.
Just to clarify,
that
yes.
I will issue the report that has been prepared by my department with its recommendations to fix the anomaly the day I bring it to Cabinet. So that's what's agreed. But I'm going to do that anyway. So.
Okay, so there we can expect a report in respect of the 2012 changes but I guess the underlying anomaly, which is there as well, which I hope there is scope to be addressed and needs to be addressed, which is the underlying anomaly in respect of the how we calculate our pensions. And Minister, I have some concern because yesterday we heard in this House, and I know you spoken previously about the move to, for example, the new supplementary pension system, which is basically, you know, opt-in, I'm trying to remember the correct phrasing. The auto-enrolment. So the new auto-enrolment pension system, and that has been discussed. I believe a concern that we have is, we've also been hearing that the total contribution approach is going to be brought in by 2020, and that the total contribution approach had the potential to address some of the concerns in terms of the unfair averaging system which we had, though I recognise there are still concerns around recognition of care, how we have a care credit, which the total contribution approach would need to factor. How do we include and reflect care in the total contribution approach? And I would also note that in the auto-enrolment system, how we recognise and support care is also going to be an issue in terms of ensuring that we don't have yet another gender pension gap down the line from that system. So there's a whole question there. But my concern is we're moving towards this new auto-enrolment system. What is happening around the move to the total contribution approach? And if we are not going to deliver that by 2020, and indeed even if we are going to deliver it by 2020, I think we still should be doing something to address the basic inequality in our averaging system. And it's an inequality and an inequality. We have the inequality of women pushed out by the marriage bar. And as I said yesterday, I believe that in 1973, when we were told that the marriage bar was not acceptable, we should also have been putting in place at that time pension systems to address the impact that it had had since it had been noted as being inequitable, which we didn't do. We also have the residual, and on top of that kind of core first insult in terms of issues like the marriage bar, we also have the ongoing factor of something that deeply penalises anybody who takes a period out of time for caring, even if they have made the same amount of contributions as somebody else over their lifetime. I mean, it's an unacceptable inequality, Minister, and it's not something we can stand over, especially as a government who have committed to gender inequality proofing our budget. So in this regard, this is why it sits with you, Minister, but it also sits with DPAR, and I've highlighted this. DPAR are responsible for the implementation of the legislation around public duty in terms of equality and human rights proofing. DPAR are also fundamentally responsible in terms of the gender and equality proofing of our budget every year. And I cannot see how this stand up. I don't know how it slipped through another year. It's like a glaring black mark on any future report we produce in terms of equality. There's no way it stands up on gender or on equality. In that regard, I think that the addressing in this report, I suggest that the solution to this anomaly should not simply be sought from within the resources allocated to the Department of Social Protection, because the solution to this needs to be found in the wider scope. And Minister, we discussed as before, we spend £2.6 billion on private pension tax relief in this country. In many cases, I'm sure it's important and it's merit, and it has many merits. And when we debated this in the Finance Bill, many people spoke about the various merits and the encouragement of social. There's a lot of problems, nonetheless, with how it is done, because we have another inequality, and they're piling up, but we have another inequality, which is that we give it at a marginal rate, and that we don't get, and that the many in the country who are on a low population have the not very incentivising 20% tax relief, whereas those who are already looking to be on higher incomes have a much more incentivising 40%. What I was seeking from the Department at that time was something that was in fact recommended under the Memorandum of Understanding with the Troika, which is that we should move to a standard rate of perhaps 30%, which every citizen seeking a pension and a private pension could access, which would nonetheless deliver savings, I hope, adequate to at least partially address the gaps that we have seen here. So again, I'm asking that we would consider addressing an inequality so that we can address an inequality. That's what I'm putting forward as a proposal, Minister. I will look forward to your response.
Minister.
Well, hopefully now we might actually be able to tick all these boxes now, so hold on. Right, so there's a couple of issues. The reason I think it got through the gender proofing algorithm or test is because it doesn't just affect women. So I know it affects more women than men, but only marginally. So like we have 60% women, 40% men. We're nearly equally as discriminatory to both sexes, right? So I think that's probably how it got through. But that still doesn't make it okay, right? So let's talk about the three different things that you brought up. First of all is the pensions anomaly for people that the averaging system penalised because they started work very early before they then cared for their families and then came back to work again. I have a paper, it's a report with some recommendations going to the Sub-Cabinet Economic Committee on the 18th of January. Assuming that we agree at that table, it will then go to the Cabinet Committee, the full Cabinet Committee, the following week. And as soon as it goes to Cabinet, I will issue the report, because hopefully, and please God, that day I will have agreement from my Cabinet colleagues as to how to fix the anomaly and a roadmap how to get there that will see us going forward in the following couple of months. Right? So that's the first thing. So that's the anomaly. And there sets out exactly when I'm going to deal with it, if not yet how. But when I really support you, you'll know how I'm going to deal with it, right? And you are right. It isn't money that can come from my current budget because I don't have it, right? So it's not small change. It's a big amount of money because there's a lot of people, there's 42,000 people currently affected by it today, and that's going to cost me, cost the taxpayer money, and it has to come from new money, not from my existing budget, right? To go through the other things. So the first amendment that you've asked is that we're not going to extend the homemaker scheme, so as not to be so brutal as to say no to you. But how we propose to look at how we calculate pensions in the future is going to abolish the averaging system. And when we move to total cons on the 1st of January 2020, what that will do is the averaging system will be gone, the length of time that you worked will be irrelevant. What we'll do and have arrived at after the public consultation that I launch after Christmas is the number of contributions that you need to get into each band that will be agreed through the public consultation, and there will be a sizeable carers credit. And that will be irrespective of whether you're minding your children or, in some cases, as we get older, we're minding our parents, right? So it's not prescriptive. It will be as a result of the public consultation, but we will put out a straw man, is that the right word? We'll put out examples of what we think might work, and depending on the responses that we get from both industry and individuals, that will determine what the final model looks like. And I hope we'll have an agreement by the middle of next year as to what the total cons model will look like, because then we can go about creating an IT platform to be able to manage it and to collect and pay, right? So with a view to going live on the 1st of January 2020. The second thing is separate and distinct, but it actually reflects on the E part of your amendment. So you're well aware at the moment that we have €2.6 billion worth of tax relief to both people on the 20% and on the 40% bracket, and it is unfair. The people who are earning more money get to get more tax relief than the people who are earning less money, right? The total new proposed model that we're going to, again, which is going out to public consultation after Christmas, is the auto-enrolment model. And just to put it on the record of the front page story on the Irish Independent yesterday, and whatever else was written on page 13 and 14 by the young journalist, is entirely inaccurate. Where she got her information from was from an OECD report, which doesn't reflect the ambitions of what we're going to do in the department. But again, I will tell you that what we will go out to public consultation in January isn't a finished product, and the finished product will only be informed by the public responses as to what it is they want to see. And I've said it on the record before, and I'll say it again here in this House. Whatever system we come from and we conform to at the end of that couple of months' public consultation will be entirely fair to everybody. So there won't be people getting more tax relief on a new auto-enrolment scheme because they happen to earn more money than people who will get less tax relief in the lower tax brackets. What you will do is that within a proposed salary bracket of maybe, and this is only throwing this out now, of maybe between 20 grand and 60 grand, if you put in a fiver, your employer will put in a fiver and the state might put in 250. But again, I'm only plucking those figures from the sky because that will be determined by industry collaborating with us, individuals making suggestions of what it is they think they can afford. So again, the misleading and entirely inaccurate statement on the front of the paper yesterday that said people would have to put €200 a week or a month from their payment into pension schemes is wrong, and actually sets, I think, a very misleading tone for what should be a very exciting reform of pensions, of tax relief, and a way for young people to be able to save, to have extra over and above money than they would normally get from either the non-contributing pension or the contributing pension when they reach 66 or 67. So look, all of what you've asked for, except the homemakers' credit, right, is going to be provided for in the anomaly provision on the 18th of January, in the total cons public consultation, the auto-enrolment public consultation, and I will only guarantee you that there will be a sizeable caring credit that will form part of the new total contributions model, and the averaging system that did affect people in probably, I won't call it unfair, but it made some people not get as much money as they should have maybe expected to get, will be entirely gone out of the new total cons system. But the exact parameters of what that will be determined and arrived upon from the public consultation.
Thank you very much, Minister. I'm very much welcome your comment in terms of a care credit. It's something that I've pushed for years and years and years, so I'm back since my time with Older and Bolder and with the National Women's Council, and I'm just very happy that that is on the agenda in terms of total contributions approach. It's very good to hear. I'm also glad to hear that in terms of the auto-enrolment model, that you are looking at three-part contribution, that it would be employees, but employers also, and of course the state. So I think that three-part element, whatever way it may finally be constructed, I think is important and an important principle. Minister, in recognition of the fact that you're moving forward and that we have extensive work and we will be looking at extensively at pensions in this area, I will not be pressing this amendment at this point now, but I would note that nonetheless, despite these wonderful visions for the future, we do have a cohort in Ireland who are deeply disadvantaged, who need to be, who cannot simply wait for them to move on for the next few years, for 2020 even, for example. There are a cohort of people who are suffering inequality every single time they go to get their pension. On a weekly basis, they are feeling the impact of that inequity. And in some cases, it is those who have this as a very small independent income, who may not be able to apply, for example, for the non-contributory pension because of their partner or their other forms of means, but who individually, their pension represents the message the state sends to them about how their contribution over their life has been valued. So I will be continuing to press in respect of the homemakers credit, and I know that older women and men across Ireland, because of course you're right, there are men, particularly men who travelled and worked, for example, in England for years, or turned and returned, who have been disadvantaged by this averaging system. I know that they will continue to campaign, and I think that if, Minister, we wish to build faith in these new systems, one of the strongest signals that the state could send in order to build confidence in these new auto-enrolment system, in the new total contribution system, would be to, financially, I know it is costly, but importantly and symbolically vitally important, send the signal that we have addressed a past inequity. And I think that would set a very positive tone for our better strategies as we move forward. I know that's not within your gift at this point, Minister, but I would like to just mention
Thank you, Senator Higgins. Minister.
Very just briefly, because it might be. First of all, the anomaly is going to be dealt with in January, right? So that's separate. But for those people that you're talking about, when we introduce total cons, it isn't just for new entrants. So there will be a period, I don't know whether it'll be 1 year or 3 years, or again, that will be determined during the public consultation. There'll be a period where people who are currently being adjudicated under the averaging system can move to total cons. So and then that credit, whatever it happens to be, whether it's 10 years, 20 years, whatever we determine during the public consultation, they can attribute that to their future payments as well. So,
okay. So you did move it, I understand. So
yes.
Can you now, are you withdrawing it?
I'll withdraw it. Yeah.
Withdrawn, is that agreed? Okay. Now, Schedule 1, the Schedule 1 be scheduled to bill, is that agreed? Schedule 2, the Schedule 2 be scheduled to bill, is that agreed? Schedule 3, the Schedule 3, I need somebody. Oh, sorry, I mean, Mr. I'm sure you're happy to agree, but I actually need somebody who's a member of the chat. So Schedule 1 has been agreed, is that right? Agreed. Schedule 2, the Schedule 2 be scheduled to bill, is that agreed? Schedule 3, the Schedule 3 be scheduled to bill, is that agreed? Agreed. Now, that this be the title to the bill, an Act to amend and extend the Social Welfare Acts, the Maternity Protection Act 1994, the National Training Fund Act 2000, and to provide for related matters. Is the title agreed? Now, bill reported without amendment. When is it proposed to take the next stage? Tomorrow. No. Oh, it's tomorrow? Yeah. No, it's actually tomorrow. Is that agreed? Okay, that now concludes item 2, the Social Welfare Bill 2017 committee stage. Thank you all very much, and we'll just allow the ministers to swap around, and we'll go straight into the private members' bill. motion 15 regarding special needs assistance. I just welcome Minister Bruton to the House. Now, I'm going to call on Senator Ivana Bacik to move the motion, and you have 12 minutes. Oh, it's Senator Reardon.
I'll second it.
Okay, so you have 12 minutes, Senator Reardon.
And welcome, Minister, to the House. And I'm delighted, on behalf of the Labour Group, to propose this motion in defence of the employment rights of special needs assistants. And before I do so, I just want to acknowledge the attendance in the gallery this afternoon of members of Impact and some of the special needs assistants that they represent, and represent very ably and with distinction. It mightn't be well known to many members of this House. In fact, it mightn't be well known to many members of the Irish public in general that Impact have balloted for industrial action out of a complete frustration with the actions of the, or inactions, we should be said, of the Department of Education. I think most people would agree that when a profession such as special needs assistants are forced to ballot for industrial action, that something has gone seriously wrong. SNAs are dedicated to the welfare of the students that they work with. Anybody who has ever come across an SNA in any school in Ireland knows that that is their primary concern. So when it comes to a situation that the union that represents over 8,000 special needs assistants feels it has to ballot for industrial action, and then when 97% of those SNAs agree that industrial action is the route that they feel and is necessary to pursue, then something is quite seriously wrong. Now, I myself have some history with this issue. Many people in the Labour Party have. I would have initiated an Oireachtas committee report on the role of the SNA in the last Oireachtas that was completed by then Senator Mary Moran and published in January of 2016. I recall a number of years ago having a public meeting in my own constituency on the issue, and the public meeting was stuffed out the door with people just willing to tell their story. And what always comes back, and happened again this afternoon at our briefing for all members of the Oireachtas, and I want to thank members of the Oireachtas for attending to hear the stories of SNAs, it is never, ever, ever about money. It is never, ever, ever about money when it comes to special needs assistants. Fundamentally, Minister, what they are asking for is respect. Now, we could spend hours talking about the respect or disrespect that special needs assistants get within the walls of the schools in which they work in. Any SNA will tell you stories that they have heard themselves or witnessed themselves about menial tasks that they've been asked to undertake, about the fact that they're referred to by their first name while every other adult in the school is referred to by their second name, a basic lack of value placed upon them as professionals in an educational setting. But we're not here to talk about that. We're also not here to talk about the numbers of SNAs in the system, which have been obviously increased in the last government and again increased by this government. That's to be welcomed, but that's not the point. The point is the way that SNAs themselves are treated by the Department of Education. And fundamentally, it comes down to the timing of the allocations that are done. Now, Minister, I know in the last week and earlier this month, it was relayed to Impact that situation will change, and from May of next year the allocations will be known, and so SNAs can actually plan for September in future, and that is to be welcomed. But it is very late in the game for SNAs to know that, and it's very, very disappointing that they had to ballot for industrial action before they got such clarification from your department. There are still a huge number of outlining issues when it comes to this current situation with special needs assistants. You mentioned in your counter-motion the fact that a review is being undertaken by the Special Counsel for Special Education in relation to the role of the SNA. Impact informed us this afternoon that they have no role, no involvement, no engagement in that review whatever. And I think it's quite staggering that if the department is to pretend that the SNA is respected, that the body that represents the vast, vast bulk of SNAs has no involvement in this review. Now, you can suggest to me that that's not the case. Well then, if that's not the case, why would senior members of Impact be stating it so categorically in an open forum this afternoon. There are things that were raised this afternoon, Minister, which quite frankly really shocked me, and I thought I knew this issue inside out. Issues such as SNAs at second level, the month of June, being asked to be on site doing fundamentally menial tasks. Gardening was mentioned, painting was mentioned, just being on site for the month of June was mentioned at second level. And I think that's something that, to be honest, anybody would find quite reprehensible from an employment rights perspective. No Board of Management representation. Everybody else in an educational setting would have representation on the Board of Management. The parents would have representation on the Board of Management. The patron would have representation on the Board of Management, but not the special needs assistants. No involvement in the care plan for individual students. So the students that are under their care, the students that they have been assigned to help during the day, when a care plan is put together by the school, the SNA is not involved in that care plan. It comes back again to the issue of respect. Now, I know, Minister, you're not going to want to micromanage every single school and the way every single school or school principal deals with an individual SNA or group of SNAs in their school, but the leadership in education does come from the top, and I would suggest that that leadership at the moment is sorely lacking. Issue also, a small issue, it might be suggested, but again it comes down to basic respect. Bereavement leave. You're a teacher, bereavement leave is 5 days. You're an SNA, bereavement leave is 3 days. All these small things add up to fundamentally in our education system, SNAs believing that they are not respected, that they don't have security of work, that they can't plan for the future, and that every June, in second level, obviously I've mentioned the fact that in June they can be assigned menial tasks, but every June in primary or in secondary school, planning for the future, being able to look forward to September with some kind of security of tenure. Up until now, SNAs thinking, well, I'm not sure if I'll be back in this school in September. Should I go off and apply for another job? Well, maybe no, I shouldn't, because I might still retain this job. And all that insecurity around bills that everybody has to pay, mortgage repayments, etc. So fundamentally, Minister, what we're asking you to do is to change this entire attitude that the Department has in relation to special needs assistants, to acknowledge them as a vital component of our educational system, to acknowledge the fact that the over 10,000 special needs assistants that we have, approaching 14,000 at this stage, are vital in the roles that they have. They are not an add-on to the system. They are not a luxury. They are not, as I say, a kind of an add-on to a system. They need to be clearly defined. They need to be given the respect and value that at this stage they deserve. And I think it is only fitting that the report, as compiled by former Senator Mary Moran, will be at the top of any review mechanism that is in place. So we have a few fundamental questions. I know it is the way of things that you put down a counter-motion, and you've spoken in your counter-motion about the number of SNAs that have been allocated, and that's fine, and that's to be welcomed. But it is the employment rights, it is the value placed on those individual SNAs is what we are talking to today. And again, it doesn't come down to money. It doesn't come down to the salary expectation or the wage expectation that any SNA has. Whenever I have a discussion, or any of my Labour colleagues ever have a discussion with a special needs assistant, money is never raised. It is always about the respect that they are given from within the school and from without the school, from the department. So, fundamentally, Minister, we are asking you to expand on what you have said in your counter-motion in relation to the review. Are you actually going to engage with the practitioners and their representatives in compiling that review? I do find it incredibly frustrating when dealing with the department that there always seems to be a review, there always seems to be a committee, there always seems to be a paper written by somebody else, and your own department seem unwilling or unable to make a definite decision outside of another body compiling a report. I mean, there are many issues in the areas of education that we feel in the Labour group that the government are falling down upon. We have the ongoing issue of pay discrimination at primary and second level teachers, which was raised again with me today, which again noises from government aren't helping. We know that there are school communities around the country. Even the phone call today I got from Councillor Mark Wall in Kildare about St Paul's Secondary School in Monster and their lack of certainty as to where their school building is, Minister. All these issues that are coming down the tracks in terms of education. And what we get from the department are action plan after action plan after action plan, yet when a very, very good piece of work is compiled by an Oireachtas committee on education in this House, it seems to be sitting on a shelf now for almost 2 years, there is inaction when it comes to a cross-party, bipartisan approach to the future of the SNA. So, Minister, let's get beyond the numbers of SNAs that have been allocated by your department, because that has been acknowledged. We want to fundamentally deal with the issue of respect, to ensure that we have value for the special needs assistants in the system, and to engage with them and their representatives in any review that you are undertaking as Minister. We will be calling a vote on our motion, Cathaoirleach. We are sticking with our motion as laid down. We reject the counter-motion, and we want support from all corners of this House in supporting our motion.
Thank you, Senator O'Riordan. Senator Batchik, you have 8 minutes.
I'd like to welcome you to the House, Minister. You're very welcome. And I would like to formally second the motion. And
I think Senator O'Riordan, you did move it, did you? I did. Yeah,
I think he did move it. And I just reiterate that we're not supporting the government counter-motion, if that needs to be emphasised. I just want to commend my colleague Senator O'Riordan for moving this motion on behalf of Labour senators, and it arises out of, as he said, his own long experience as a teacher and a principal, and seeing at first hand the important role of SNAs. And I should say that in my own experience as a parent of children in primary school or a national school, I know again very well just the invaluable contribution made in supporting the work of schools by SNAs. Increasingly in so many classrooms across the country, Minister, as you'll be well aware, the SNAs form a vital part of the school and educational infrastructure. And I want to thank Senator O'Riordan also for facilitating a briefing earlier today with Impact representing SNAs, and to welcome our colleagues from Impact and those representing SNAs in the public gallery for this debate. And we are disappointed that the government has put in a counter-motion. We do believe that the wording of our own motion is a sensible wording, it's reasonable, and it reflects the real concerns and views of SNAs. And again, to reiterate what we heard from Kevin Callanan and others at the Impact briefing earlier, and what, as Senator O'Riordan has said, that this motion and the principles behind it are not about money and not about the pay of SNAs. They're about respect for SNAs, about the treatment and conditions and employment rights of SNAs, and in particular their desire and their absolute entitlement to be treated with respect in the workplace. And as I said, that really is reflected in the wording of our motion. In particular, what our motion seeks to emphasise is the huge problems that delayed publication of SNA allocations causes to individual SNAs, and indeed to schools too, which have to plan for years ahead. And in particular this year, what prompted the impact ballot that Senator O'Riordan has spoken about was the delayed publication of SNA allocations to July, just 2 months before the new term for the 2017-18 school year started. And this has caused enormous uncertainty for thousands of SNAs around the country who simply did not know until the last minute whether they had a job to go back to in September. And it's not only is it not respectful to the SNAs, to the special needs assistants, but of course also it's not respectful to the schools and indeed to the parents and most importantly the children whose education depends on their SNA allocation. And I just wanted briefly to address perhaps some of the broader points that I think our motion also reflects, and that is really the importance of SNAs in ensuring that our children achieve their full potential in schools. And many of us were very disturbed by comments made around the budget this year, where Minister Donoghue was, I think, quoted as suggesting that, as being critical of the rise in SNAs. quoted as saying that he was alarmed over rapidly escalating costs, referring to the fact that there are more SNAs than Gardaí. And I think this language was heavily criticised by Lorraine Dempsey of the Special Needs Parents Association. She said she was concerned about the dangerous use of language. And indeed, if one looks at some of the commentary at the time, an editorial in the Irish Times in November pointed out that yes, there has been an incidence of special needs increasing, of SNA allocations increasing, but this is due to rising child population, medical advances, better diagnosis and better recognition of the rights of children to be schooled in a mainstream educational setting. After years of playing catch-up, we're finally making progress in meeting the needs of some of our most vulnerable children. The incidence of special needs of diagnosis is increasing, but so too are the numbers of children who would previously not have been in mainstream schools increasing. So we see, for example, 700 more children with special needs entering third level now than 2 years ago, up 31%. So we're seeing dramatically improved outcomes for children and young adults as a result of SNA allocations, and children, as I say, being enabled for the first time in our education system to meet their full potential. Now, Senator Reardon talked also about recent announcements, Minister, that we very much welcome by yourself last week, I think, in fact, after we had submitted the text of this motion, if I'm correct, Minister, and we very much welcome your announcement reported on the 6th of December that a total of 130 additional special needs assistants would be made available for allocation to schools between January and June 2018, and that schools would be informed of their allocation for the 2018 to 19 school year much earlier next summer. I think he said by May of next year instead of late summer. Well, that move, of course, your announcement was welcomed by the Special Needs Parents Association, and we would also welcome it, as indeed will the SNAs and Impact. But it still is simply not good enough that we have waited till now, until it seems the last minute before we debate this motion, for that announcement to be made, particularly as back in 2016 the Oireachtas Education Committee, as Senator Reardon has said, recommended specifically that allocations be made earlier, ideally in March or April of the year preceding the year in which they are to be allocated. So, we are disappointed by the motion. We do recognise the advances, we recognise the increases and the fact that there will be over 14,000 special needs assistants in place as a result of your recent announcement. And we very much recognise and welcome the great increase in support that has represented for children with special needs in our educational system. But we do feel that not enough is yet being done to recognise the employment rights of SNAs, to improve their working conditions, and above all to ensure that they are treated in the workplace with the respect to which they really are entitled and which they deserve, given the enormously vital contribution they make to our educational system. So, Minister, I hope you will listen to what we are putting forward. I know other Labour colleagues will also be speaking on this, and we are again appealing to colleagues from across the House to support our motion and to reject the government counter-motion on the basis that we need to ensure SNAs are treated with respect in the workplace.
Thanks very much, Senator Batchik. The next speaker is Senator Byrne. And Senator, I'm just going to ask you to move Amendment 1 on the order paper.
I so move.
Thank you. Go ahead. You have 8 minutes.
Thanks very much indeed, Lascar Hirlik, and first of all to welcome the Minister here this afternoon. And I'd like to welcome our guests here in the gallery as well, who are representing the SNA Association. So just to say that you're very welcome here as well. I suppose during the worst years in the recession, I suppose the SNAs were not cut back by the current government, and certainly in terms of emphasis was put in terms of learning outcomes, and everything was put in place to support the students that were most vulnerable, and I think that this is most important. There's been over 3,000 extra SNAs announced by the Minister and since 2016, and I think as well that this has been very, very welcome. I know in my own area where I come from that we've had a number of special needs assistance posts announced, and I know that I'm involved in a school that has a number of special needs assistants, and I would have to say that I haven't come across a lot of the cases which our Senator Reardon was referring to, where people were being asked to do things outside their remit. But, obviously the Senator has received complaints in that respect, but I personally haven't come across them, and I've been involved in many schools over many, many years. The increased investment reflects, I suppose, the priority which the government has put in helping children with special education needs to fulfil their potential. Going back to the report that was put in place, and to pay compliment to former Senator Butler and her committee at the time, I know that from my own assessment and meeting with the Minister that they have taken that report very much on board, and when the Minister asked for a review of it, that he also asked that the points made by the committee at the time, and I understand that that is still what's being looked at and being covered in relation to it. So I do think that in terms of the department that they are taking, the requests of special needs. Back in 2000, special needs assistance, back in 2013, there was actually a grievance support system put in place by the then Minister for Education, Rory Quinn. And I understand that that's still in place and that that is still being worked upon and has been strengthened as well. And that was back as far as 2013. And this is where we'll say that the SNAs, if they had any grievance, they could speak to the school management, they could bring it further, and that is still there. So, I mean, there is, I suppose, a situation where people, if they have a problem, they can actually move their complaint along. And I know that the Minister is committed to the effective operation of the scheme in consultation with education partners as provided for in the National Industrial Relations Agreements. And as I was saying, procedures are in place involving schools, school management bodies. I sit on a board of management myself. I know that we have had not complaints from, we'll say, people representing SNAs, but we have had grievances in the past, and they are aired at board of management meetings. So from my own experience, I do think that board of managements are very open and very receptive to listening, certainly, and dealing with the issues of the day. I suppose I know that the Minister, I know from previously speaking to him that he's willing to engage with staff interests and school management in relation to all areas. So I do believe that the Minister is very committed, and the Department to it. I suppose the fact that there has been a doubling of the number of special classes as well. And in terms of ASD units, I know that there has been a spread of the ASD units, which are very, very necessary right across the country in terms of, it's not just in Dublin, it's in the regions, it's in the small towns, it's in the urban and rural areas where schools have now specific units, and that children that were not able to go to mainstream class before, that they are now able to actually attend mainstream schools. I want to pay tribute to all the special needs assistants throughout the country, because I think that they do absolutely fantastic and Trojan work, and it's people like them that have made it so easy for children to be able to go, and they're so supportive to the students that they work with as well. And I think that this is really, really to be commended, because these people, that they deserve to be really recognised for the work that they do, because they have made the lives of so many children and so many students, and the lives of families, so much easier as well, because it's the support that they give in conjunction with working with the teacher and with the family support and the school support. So overall, I'd just like to propose the counter motion, certainly, and move it, and just to welcome the fact that there is engagement to do with SNAs, but there is procedures there in place, and I suppose anything that can happen to strengthen the role of people certainly is to be welcomed. But I do think that there is a lot of support in place. Thank you.
Thank you very much, Senator Byrne. Our next speaker is Senator Gallagher, and you have 8 minutes.
Laska Hirlach, Tara Bawayam Erdus Falcher, Korot Kujin, Shah Shahanu, August Bawayam Falcher, Worakor, and Nadini Ata, Egeshat, Len Asha, and you Foster. At the outset, I would like to say that Fianna Fáil fully supports the Labour motion here this afternoon, and I compliment the Labour members on bringing it forward. I know from Fianna Fáil perspective we've been consistently critical of the government in the manner in which it allocates special needs assistance, and it's something that has been going on now for maybe over a 4-year period, and it's very unfair on special needs assistance, number one, very unfair on the schools and board of management, and indeed, by extension, very unfair on the children concerned. I go as far as to say that the government's treatment of people employed as special needs assistants is reprehensible and completely lacking in respect. When the 2016-2017 school year ended, management of schools still do not know how many SNEs they would be allocated, or even if they could retain their current staff. This also means that people employed as SNEs did not know whether they would be employed next year or not. The situation created unnecessary hardship as things were let go down to the very wire. As I said earlier, it is unfair on SNEs who have to live with this uncertainty, and often they do not know whether they are going to have a job or not. And I think everybody would agree that is a very regrettable situation to be in. Again, we ended up, when announcements were finally made, that school boards of management had to come in, and teaching staff had to come in during the summer and try and put arrangements in place that they would be good to go come the start of the academic year in September. And again, bearing in mind that boards of management members, as we all know, are doing that in a voluntary capacity, and the teachers themselves, to be fair, are off on annual leave. I think it is very unfair that they be asked to do that. And I think it is time, Minister, that the special needs allocation was given greater predictability and announced before it gets too late. I think it should be announced no later than mid-May, I think, to give everybody time to know exactly where they stand and to put proper plans in place so that the special needs assistants can plan as to whether they know they have a job in their existing school or whether they have to make plans to try and find employment elsewhere. I think it is important that when we are discussing the issue of special needs education, we must not focus exclusively on the cost to the state. I think that would be a mistake. Rather, we must reflect on the real positive impact that SNEs had on the well-being of our children with special needs. I do hear reports that the Minister of Public Expenditure has raised concerns with you, Minister, in relation to the cost of special needs in Irish schools. I think it is important, Minister, that you hold firm here and that we do not lose sight of the bigger picture and the very important picture. Special needs education has transformed over the last 20 years, and we can be very proud of the progress we have made in that regard. And I think it is imperative that the real progress that we have made, that we do not take a step back in that regard. And I feel that nothing must be done to jeopardise that progress we have made, because it is important that each child who receives support from the Department of Education is classified as a valuable member of our society, and that the state must support their learning and development as much as possible. I am reminded, when discussing this particular subject, of the great liberator, American liberator Frederick Douglass, who way back in the mid-80s came away with a famous quote that we often use, and I think it is very apt that we use it here today. And his quote was, "It is easier to build strong children than it is to repair broken men."
Thank you very much, Senator Gallagher. Our next speaker is Senator Moore Devine. You have 8 minutes.
And Kate Mila Falcha to the representatives of Impact Trade Unions here in the gallery. The ongoing working commitment which Impact and its members have vested in this sector is second to none. And if they were treated with any respect at all by this government, we wouldn't be here this evening. What we have right now, Minister, is a dysfunctional relationship between the Department of Education and Skills and the workers and families within our schools. It is not fair that the SNAs employed by the state, schools run by the state and families whose children are reliant upon SNAs are left in the lurch like this year after year. I cannot understand why, after 4 years of ongoing failure, there is still an ongoing habitual failure by the Department to publish the allocation of SNAs in a timely, sufficient fashion. It is hugely disrespectful, not just to the workers in the sector, but also to the parents and the children who depend on these services in order to access a fair playing field in education. The signal that this ongoing failure by the Department sends to our SNAs and children is that they are not valued, that they seem to be an afterthought. The agreements they have with the Department around deadlines, etc., don't seem to be worth the paper they're written on. What we do know for sure is that the Department is fully aware of how important and how serious this issue is for workers in the sector. We know this because the Department of Education and Skills published a report in January 2016 entitled A Report on the Role of Special Needs Assistant. And within that report, looking specifically at recommendation 9 of the report, I quote, SNA allocations need to be made at an earlier date in order to provide SNAs with the appropriate notice of their employment in advance of school years. Early allocations would also be beneficial for parents and students, as they will have clear knowledge of SNA support and they may or may not be receiving for the upcoming school year. March-April allocation deadline is preferable. This issue was explained to the Department in 2015 and it published the report in 2016 and in black and white outlined what had to be done. Minister, why has the Department failed in 2016 and 2017 to achieve this? If this happened once, it would be frustrating, but it happens every single year. It's an habitual failure by your department, and that's why we're here. Sinn Féin fully supports the decision by 97% of members of Impact to take industrial action with regards to this issue, because we respect the work that they do. We recognise their commitment to students who need their vital help. SNAs are a lifeline to any person in a school with a disability. They help students with their tasks and allow students to get on with their learning. The more inclusive we make our schools, the better of an environment we create for all students and for staff. However, the stark reality is that our students today are being taught in overcrowded classrooms with more and more costs of a supposedly free education being passed on to parents who shouldn't have to deal with sort of mental and financial distress. Voluntary contributions place a heavy burden on the family purse. SNAs have a relationship with the assigned students and they want security and continuity to strengthen that bond. At the very least, the SNA and the child should know in a timely fashion what the future of that relationship will be. This basic demand is not being met. This sort of behaviour displayed is hugely disrespectful and unacceptable by the Department. To continue to ignore the demands and the needs of SNAs in the sector is unacceptable. You were told by representatives of Impact in 2015 on the Education Committee that what you were doing and how you were treating SNAs was disrespectful, but it continued and has continued for a further 2 years. We have a situation where schools across the country are finishing their term for summer, closing their doors, and principals can't prepare their school schedules for the next term because they don't know the allocation of SNAs. SNAs are left in the lurch as to whether they will have a job to go back to. They can't apply for a new job because they may still have a job. They can't get the relevant documentation in order to apply for work, or at least prepare to apply, because they won't know what their situation will be. There is no security here and there is no certainty. It's not good enough to state that the state would continue to act like this as an employer. Not only that, but last May we had 558 schools looking to appeal their special needs allocation under the new resource model. SNAs as well as families are being left in limbo here, Minister, and with lack of clarity as to the resources that will be available to them. You need to ensure that this critical information is provided to schools in good time. It's prudent, sensible and it's doable. I'm also aware that the Government is currently carrying out a top-secret review of the SNA scheme. Could the Minister please outline the steps being taken in this review process? Who is participating in the review and whether, and it seems doubtful, trade union representation is being considered? Remember, Minister, trade unions are the only organisation that represent and protect workers. And this is disappointing that there is an attempt to block them and to keep them outside the door where the decisions are made. And just as an aside, the Amendment 2 was disappointing yesterday, that the bill, the finance bill, to reintroduce tax allowances for trade union subscriptions was ruled out of order. But Sin Scéal Ella, it seems the attack on trade unions go on and on. Impact represents over 8,000 workers in this sector alone, and they are being ostracised when it comes to this issue. How can you expect to deliver a review with any sort of credibility when it doesn't contain the experiences and input from workers in the sector? The delay in publishing SNA allocations is not only in breach of the 2016 report by the Education Committee, but it undermines both the Haddington Road Agreement and the Lansdowne Road Agreement. These are provisions and deals that are already agreed to, but they are not being fulfilled. It is for these reasons and many more that we will be supporting the Labour motion this evening. We are calling on you, Minister, 1. Deal with the SNA allocations in a sufficiently timely manner that Impact have requested. 2. Provide job security to workers in the sector. And 3. Establish a procedure for grievance to be heard. These demands are not a lot to ask for, considering the vital work SNAs do. They and their staff representatives deserve your respect.
Thanks very much, Senator Devine. The next speaker is Senator Grace O'Sullivan. You have 8 minutes.
Thank you. I won't require the 8 minutes. I'm just standing to support the Labour motion and to say it's really welcome that Labour took the initiative to do this. We talk in Ireland about being an inclusive society, but the work and the role of the SNAs is to support inclusion. And I've seen it firsthand myself in schools in Tramore and through the needs of my own children. It is crucial that the SNAs get the security that is required to ensure that they can carry out their function to the best of their capability. But moreover, I stand here for those children who deserve the right and the need and the support of SNAs. And I really fully support this motion of the Labour Party and really hope that will be taken on board here today. Thank you.
Thank you very much, Senator O'Sullivan. And now our next speaker is Senator Kevin Humphreys. You have 8 minutes.
Thank you. And I'm particularly proud to stand here and actually support the SNAs. Ever since I've come into politics, I've always fought the battle for the parent, because the parent certainly valued the assistance that an SNA gives to a child in the classroom. They valued it. They knew their child couldn't go through the educational system without the support of the SNA. On many occasions, I've actually had to support the same child year after year in relation to an appeal for an SNA. I also want to acknowledge the work that the SNAs carry out in the schools, and many schools wouldn't function without the SNAs. I want to acknowledge Impact in the audience here today as the professional representations. And they are a trade union, not an association, as they were referred to earlier on. They're a professional group of people that represents workers, and they should be referred to as a professional group that represents workers and not as an association. Because for far too long we've had to fight the battle for the recognition of the trade union movement, and there's probably a strike that will take place on the 20th of December where other union members are looking for recognition and the right to negotiate. So I want to recognise the rights of Impact to negotiate on behalf of SNAs. For a number of years right across the inner city, where we have many SNAs that support schools from Sandymount to Ringsend to City Quay to Sing Street, those schools wouldn't function. There wouldn't proper integration without the help and support of SNAs. Many times the SNAs have come to me in June and said, "I've no job to go to in September."